Thank you. Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order this morning. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Nguyen. Assemblyman O'Neill.
Here. Sorry.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Here.
Chairman Yeager.
Here. We do have everybody present, so we have a quorum. Thank you all for being on time this morning. Greatly appreciate that. And want to welcome the members and members of the public who may be watching either on the legislature's website or on our YouTube channel. We are now on day 32 of the 81st session of the Nevada Legislature. Before we get started with this morning's agenda, just a few housekeeping matters. These will be familiar to most of you by now, but just in case we have new people joining us today, I'd like to go over these. One, if you are on the Zoom, if you could please mute when you're not speaking, that'll help with the audio feedback. And for our presenters who are on Zoom today, if you could remember to state your name each time before you speak, that'll help our committee secretaries prepare the minutes. If you forget to do that, I will try to remind you. I know it's not a natural thing to do. We do expect courtesy and respect in our interactions with one another. We don't always agree on policy, and I think this is probably a day where there'll be some pretty serious disagreements about the policy in front of the committee. That's perfectly okay, but we need to make sure we're being respectful of each other, of the legislative process. So please, in your testimony and comments today, if we could limit it to the policy in front of us, that would be most appreciated. And then finally, many members are using multiple devices to access this meeting. We have iPads, phones, laptops, extra monitors. So please don't see it as a sign of disrespect if members appear to be looking away. Most likely they're looking at exhibits that are uploaded online. So with that behind us, members, we're going to go to our agenda today. As you can see, we only really have one bill on the agenda today. And so at this time, I'm going to formally open Assembly Bill 141. Assembly Bill 141 revises provisions relating to evictions. And before we get started, for the members and members of the public, I did want to note that there are a couple of different amendments up on Nellis. One is proffered by the sponsor of the bill, so that obviously is a friendly amendment. And then there's also one that has been put forth by the opposition. So that I assume that one's not a friendly amendment, but we'll hear from the sponsor on that. So I wanted to welcome back to the Assembly Judiciary Committee, Assemblyman Howard Watts, who served on the committee last session. We sure miss you here in the Assembly Judiciary Committee, Assemblyman Watts, and welcome you back along with, I believe, your two co-presenters, Ms. Bordelin and Mr. Berchtold. So we'll give you three a chance to present the bill, and then I'm sure we'll have some questions. So again, welcome back, Assemblyman Watts, and the floor is yours.
Thank you, Mr. Chair, members of the committee. It's very good to be back in the Judiciary Committee. Thank you for the warm welcome. For the record, I am Assemblyman Howard Watts. I represent District 15 in Central East Las Vegas. And as noted, with me at the virtual table are Bailey Bordelin and Jim Berchtold with the Legal Aid Center of Southern Nevada. With the chair's permission, I'll give some opening remarks, and then I'll turn it over to them to walk you through the bill. Then we'll be glad to take any questions that committee members have. So Assembly Bill 41 really is aimed at preventing homelessness, and it does that in two ways. First, it removes a barrier to housing for Nevadans affected by the pandemic by automatically sealing evictions from their records. Second, it provides more time for longer-term renters that are facing removal for no cause to find substitute housing in today's tough market. As a result of the pandemic, Nevada is on the cliff of a major eviction crisis. Gwynn Center and during the pandemic found that over 500,000 Nevadans are at potential risk of eviction due to the pandemic. And as many of you are aware, the current protections that are in place on evictions are set to expire on March 31st. Communities of color will be hit the hardest, making up 2/3 of Nevada's renters, according to the Gwynn Center. These communities, as we know, have also been hit the hardest by the health and economic impacts of COVID-19. They're disproportionately cost burdened and have had home ownership pushed out of reach. Job loss and income reduction puts these households in an even more precarious position. The failure to pay rent during the pandemic is directly related to our staggering unemployment numbers during this crisis. Unemployment has reached historic highs during the pandemic, with NPR reporting last May that Nevada had the highest unemployment rate in the nation and the highest rate since the Bureau of Labor Statistics started tracking this data in 1976. Folks who work in our tourism and hospitality industry, which, as we know, is the backbone of our economy, especially in Southern Nevada, were hit the hardest, with a nearly 41% year-over-year loss of jobs at hotels, casinos, and restaurants. And in September of 2020, the Reno Gazette-Journal estimated that 38% of households that rent were experiencing unemployment. And I just want to put a finer point on that. I mean, that was about 6 months ago. More than 1 in 3 households that rent had no employment from employment income. Evictions are often the result of poverty, but they are also a cause of poverty. People who have an eviction on their record experience greater financial insecurity and housing insecurity. People want to get back to work and want to move forward with our lives. We all do. And it's critical to ensure that as we recover from this pandemic, that there is not a permanent mark on their records that's creating a barrier to prevent folks from finding new housing. That's why Assembly Bill 141 will automatically seal evictions that are granted specifically for non-payment of rent during the COVID crisis declared by the governor. And these evictions have occurred in the gaps between protections for those who didn't know how to take action to prevent themselves. Assembly Bill 141 also extends the timeline for no-cause evictions. The process for eviction is applicable only in a narrow set of circumstances. It allows a landlord to remove a tenant who is under a month-to-month or weekly rental agreement for no fault of the tenants when there's no foreseeable end date. You'll hear more about this from legal aid, but it's common to see seniors on fixed incomes living month to month in rentals. They may start with a year-long lease and then stay on in the same place for an additional 3, 4, 5, even 10 years on a month-to-month tenancy. Now imagine after you've lived in a place so long, having to pack up your entire life and figure out where to move and what your next steps are going to be within 30 days. I think that people deserve a little bit of extra time to figure out what their next steps are. And so this bill will extend those timelines from 30 days to 60 days for people who've lived in a property for 1 to 3 years, and 90 days for people who have lived in a property longer than 3 years. And that's it. That's all this bill does. And I want to take a moment to just also be really clear about what this bill does not do. Because I've received some emails from concerned property owners. Folks have read it and had some misinformation about the impacts of what it would do. Assembly Bill 141 does not remove any obligation for a renter to pay. It does not change the summary eviction process or prevent it in any way, which, when somebody fails to pay after these protections have expired, if somebody is a nuisance, if somebody is damaging a property, there is an expedited summary eviction process that this bill does not modify at all. Also, if an owner has a lease with a renter, this does not tack additional time onto the end of that lease. Stable housing has a range of positive benefits. A 2016 study by the Enterprise Community Partners found that stable housing reduces Medicaid spending by 12%, primary care use increased 20%, and emergency room visits, which are more expensive and more serious, dropped by 18%. Keeping people in stable housing is a vital tool, of course, in protecting public health and fighting COVID-19, which is why we've been enacting these protections to keep people from being evicted during the crisis in the first place. I believe that the two measures in AB 141 are critical to helping people get back on their feet and giving them the opportunity to secure new housing as we come out of this crisis. I also just want to acknowledge a couple of things real quick. I want to acknowledge the Apartment Association and the realtors and others who have been engaged in conversations about this policy. And I appreciate their willingness to talk and work towards a mutual agreement. As was noted, they do have an amendment submitted. I have not agreed to that amendment, but we're continuing to talk and we'll see if we can get to the point of an agreement. And I also just want to note briefly on that point that this bill is not to point a finger at or say that property owners have done anything wrong necessarily. We know that everyone is hurting financially in this crisis, and that includes property owners. And I know that the actors out there who have tried to reach out and work with tenants to address their issues. This is just making sure that anybody who slips through the cracks during this unprecedented crisis is able to get back up on their feet. I also just want to briefly, and it will be covered more by the other presenters, with the amendment we put forward, really looks at just clarifying the language so that it can be easily implemented by the courts. And I appreciate conversations with Judge Zaragoza that allowed us to make sure that the language was honed so that it could be implemented in the most efficient way by the courts. And with that, I will turn the floor over to my co-presenter.
Thank you, Assemblyman. Chair, members of the committee, my name is Jim Birchtold. I am a directing attorney with Legal Aid Center of Southern Nevada. Thank you very much for allowing me to present with Assemblyman Watts this morning. So as Assemblyman Watts did a really good job presenting this bill, so I don't really have a lot to cover, but as he said, this bill really only does two things, and I will walk you through those two things, starting with Section 2 of the bill, which is the provision that allows for the automatic sealing of certain types of evictions, non-payment evictions, that were issued during the pandemic. And we will be working off the conceptual amendment that Assemblyman Watts submitted. Now, Nevada law already allows for the automatic sealing of certain types of evictions. This happens automatically. The tenant doesn't need to do anything. For other types of evictions, the court has the ability to seal those evictions. If the tenant files a motion, the court can seal an eviction. For example, when the eviction was the result of something that was out, circumstances beyond the tenant's control. So what this Section 2 would do would extend the automatic sealing that is already in place to non-payment evictions that have occurred during the pandemic. So basically, any eviction from March 2020 forward until the state of emergency stops would be automatically sealed. Now, why is this important? It's important for a couple of reasons. First, an eviction can be a huge black mark on a tenant's record that can prevent them from finding new housing. Some landlords will simply not rent to someone who has an eviction on their record. And we are already seeing this. For those evictions that have snuck through all of the protections in place, we are already seeing tenants who are finding it difficult to find new housing. So the second reason is this is important, this Section 2 is important, is because evictions have been sneaking through the protections that were in place. Now, during the pandemic, there have been broad protections for tenants. The idea was that there would be moratoriums in place preventing evictions, while at the same time there would be millions of dollars in rental assistance flowing to the states for distribution to the tenants and payments to the landlords. But those protections, those moratoriums, were incredibly confusing. There were federal moratoriums, there were state moratoriums. Those moratoriums would shift, they would morph. So it was difficult for housing experts to keep on top of the current status of the moratoriums, and it was impossible for the tenants. So what the tenants heard was, there is a moratorium in place, so if I receive an eviction notice, I don't need to do anything. So a lot of evictions were granted by default because the tenant didn't know that they had to respond. There was also a huge problem with the rental assistance getting into the hands of the tenants. That was a Herculean task administratively. So a lot of tenants were evicted while they were waiting for their rental assistance application to be approved. So that's really what this bill is targeting. For those evictions that snuck through the cracks, non-payment evictions would be automatically sealed to allow the Nevadans who are facing that black mark on their record to move on with their lives, get back on their feet. Now, the second thing in section 1, the second thing that this bill does is extend the time frame for no cause evictions. So that will make more sense if I give you a little background on no cause evictions. No cause evictions, unlike other evictions in Nevada, where the tenant is doing something wrong, the tenant is not paying their rent, the tenant is causing a nuisance, the tenant is breaching their lease agreement. No cause evictions are used when the tenant is doing nothing wrong, but the landlord simply wants them out. Now, they can be used in two types of situations: where the tenant currently does not have a lease and never had a lease agreement, or where the tenant had a written lease agreement, but that lease agreement has expired and the tenant has been allowed to remain on the property with the permission of the landlord. Now, in those situations, if the tenant pays monthly, if the tenant is a month-to-month tenant, the landlord can issue a 30-day notice and evict the tenant. If the tenant is a weekly tenant, meaning the tenant pays their rent every week, then the landlord can issue a 7-day notice and evict the tenant. So why is this problematic? These are not temporary tenancies we're talking about. We have seen situations where tenants can be on the property for 10, 15 years while in a month-to-month tenancy. So for a tenant who has done nothing wrong to all of a sudden receive a 30-day notice saying you have to be out by 30 days, that can be incredibly difficult and sometimes impossible, especially for tenants who are seniors, tenants who are disabled or have some health issues, or tenants who are on fixed incomes. So during that 30 days, what they're being asked to do is find a new place that they can afford, that meets their needs, is close to their doctors, to the bus line, to schools, to figure out how to physically move a lifetime's worth of possessions. And to do this, all while trying to come up with a first and last month's rent and a deposit. Because remember, during that period, the tenant is still paying rent to the landlord, and the landlord, the current landlord, and the landlord has their deposit. So for tenants on a fixed income, trying to even come up with that money to find a new place to live is incredibly difficult. So what this bill would do, it would extend those timelines for long-term tenants who have done nothing wrong. So for tenants who have lived in the property more than 1 year, 1 to 3 years, it would require a 60-day notice to evict those tenants. For tenants who have lived in the property more than 3 years, it would require a 90-day notice to those tenants. And those timelines are not out of sync with what other states are doing. Now, as I would just like to touch on finally what Assemblyman Watts noted, there's been some confusion and misinformation about what this bill does. Again, what this bill does not do is give tenants the right to live in a property for free. During that 60-day period, that 30-day, 60-day period, 90-day period, the tenant has to pay rent. If the tenant doesn't pay rent, then the landlord can evict the tenant for non-payment of rent, which is a totally separate notice and process, just like any other tenant. What this bill also does not do, it does not automatically extend every 12-month lease. There have been some suggestions that, well, if there's a 12-month lease, that means the tenant's on the property for 12 months, which means they get an additional 60 days. That is absolutely incorrect. This only applies to tenants who do not have a written lease. At the end of a written lease, a landlord can give the tenant a notice and evict the tenant if the landlord chooses not to renew that lease. That is a totally different notice and a totally different process. Finally, this bill does not require landlords to house problem tenants. In fact, it does just the opposite. We're talking about the tenants who have done nothing wrong. These are no-cause evictions, meaning the tenant is paying their rent. The tenant is complying with the terms of whatever agreement they have with the landlord. The landlord simply wants the property back. And finally, does this apply to every tenant? No. Again, it only applies in the narrow slice of tenants where the tenant never had a lease agreement, or the tenant had a lease agreement that has expired, but the tenant has lived on the property for a long term at the consent of the landlord. So what this really does, it just extends the timeframes to a realistic point that the tenant has the ability to find a new place in a tight housing market, to arrange for the physical move of all their possessions, and to come up with the money to make that happen. So I will be happy to answer any questions you might have.
Thank you so much, Mr. Berchtold. Ms. Bordelin, would you like to provide comments before we take questions?
I think we could jump into questions because I'm sure that will be the points that I would have added. So why don't we go ahead and do that?
Okay, great. Thank you. Thank you, Assemblyman Watts and Mr. Berchtold, for the presentation of the bill. I know I have a number of questions. I'm going to start first with Assemblywoman Cohen, who I believe has kind of a foundational question, and then we'll take it up from there.
Thank you, Chair. Sorry about that. I was having trouble with my mouse. And thank you all for the presentation. Can you give us just basically a little primer and refresh our recollection on summary evictions and what that process is?
Sure, Bailey Bordelin for the record. So I think that's where a lot of the confusion is, that there's a lot of different types of evictions, a lot of roads to evictions, and we're dealing with different pieces in different ones. So while the record sealing piece is dealing with non-payment, the no-cause piece is not dealing with non-payment. But summary evictions occur when somebody falls behind on rent, and as soon as one day after they are delinquent on rent, the landlord can issue a 7-day notice to pay rent or quit, is what we call it. That is important in the context of the record sealing piece. So in that 7 days, the tenant has the ability to become current on rent. So they have a legal opportunity to tender that rent and prevent the eviction from occurring. They have the opportunity to leave the property, in which case an eviction won't be necessary to be executed against them because they will have left the property. Or they can file an answer with the court. And that is where summary eviction is very unique to Nevada, in that the tenant has to initiate, we call it filing an answer, but the tenant is initiating the court proceeding, and it is actually the first filing with the court happens by the person who wishes to assert a defense. If you do none of those three things, if you do not leave, if you do not become current on rent, and you do not file an answer, the landlord can move to have the eviction summarily granted without a hearing. And then that would get sent to the constable, who would effectuate the lockout at the property. And so that's a complicated process, and that's where people have fallen through the non-payment of rent evictions in this state of emergency. So while there have been eviction protections in place, it requires the tenant to still respond to that notice, to find out that there's a declaration that they need to fill out and give to their landlord, and then file it into the court with their answer, with their proof of service. And if they just heard there was a moratorium and didn't do those things, those are the people who now have non-payment of rent eviction records, despite the protections that have been in place.
This is Assemblyman Watts. I would also just briefly add on to that, the summary eviction process is also available for some of the other issues that were brought up in our testimony, including breach of the lease agreement, becoming a nuisance. And this, I think, often is mentioned in the context of somebody who's damaging or harming the property. And I also just want to, again, be extremely clear that the provisions in Section 2 of the bill only apply to any eviction related to non-payment of rent. And in fact, many of the eviction protections that have been put in place have also been specific to non-payment, to the financial burden. And so if people have been a nuisance or damaging a property, those evictions may still occur, and those evictions will not be sealed under the provisions of Assembly Bill 141.
Thank you. Thank you, Chair.
You're welcome. So I have a number of questions so far, and I'll just give the order so everyone knows, and I'm sure we have some additional ones, but we have Vice Chair Wynn, Assemblywoman Bilbray Axelrod, Assemblyman Wheeler, Assemblywoman Krasner, Assemblywoman Gonzalez, and Assemblywoman Hanson, is who I have on the list so far. I see Assemblywoman Kasama has her hand up as well, so I'm going to add her to the list, and Assemblywoman Hardy. So you might get a question from everybody, which would be a first on the committee, but we'll start the list there. Vice Chair Wynn, would you like to ask a question or two?
Yes. In reviewing Section 1, where you have these amended or new proposed like dates and timelines for how they are, can you tell me a little bit about how you drafted that? Did we look at best practices? I know that in this body, unfortunately, it seems like a lot of times we arbitrarily pick numbers. I don't know if the previous numbers that were like listed in there, like the 7 days or 10 days or any of those, were arbitrary, or if there's any kind of like data or evidence-based like practice behind that.
Sure, Bailey Bordelin for the record. That is a great question. From a housing policy perspective, I would actually say the progressive trend that is occurring that housing advocates are working towards are just cause evictions. So there are actually a lot of localities and one state who has done away with no cause eviction. And that is kind of the next frontier of you should have to have a reason to be able to evict somebody. We did not propose that in this bill. I think Assemblyman Watts can speak to how he picked what he thought was reasonable, but this is in sync with a lot of what's going on nationally. Evictions are a little bit difficult when you look at the data because it is such a state-by-state beast. But a lot of states do offer 60 days. What we're doing differently is creating a tiered system. So where a lot of states just have 60 days across the board, we put in something that we thought was more justifiable based on actual circumstances. And I think the other piece to this is, I don't want to speak for the courts, but court capacity and the systems capacities that we're dealing with. And so something that we see a lot at legal aid is people get a 30 days and it is just not doable. They can't move out in 30 days and they start to panic and they reach out for help and they ask what they can do. And the answer is you can file an answer with the court and ask for more time. And so we think that by giving people more time from the outset, will reduce that tension and need to litigate and need to go to the court and request more time in the first place. If people don't need the time, they can always agree with their landlord once they've secured housing and find a date to end earlier. They don't have to stay for the duration of that whole time, but it puts more options on the table without requiring court involvement.
Sarah, I know you have a lot of questions. Can I have a brief follow-up though?
Please go ahead.
I just have some concerns. I was curious if there was like any evidence based on those numbers. Obviously, you know, we have a lot further to go potentially in this realm and in this space. So I appreciate you, you know, elaborating, you know, getting away from no cause evictions into a more reasonable like realm. Obviously, that's not what this bill does today. I have concerns, and not that I want to put out like ideas for people to be bad players and have bad intent, but what would stop someone from like just making their tenancies always like 11 months to avoid this, to avoid like longer time periods?
Thank you for that question, Vice Chair. This is Assemblyman Watts for the record. I want to address both your initial question as well as your follow-up, and I'll start with the follow-up. Just to go back to another point, you know, this does not apply to lease agreements. And so I want to make that extremely clear for the record. So if you have a 12-month lease agreement, all of the provisions of Section 1, they do not grant an additional 30, 60, or 90 days at the end of that lease agreement. Under the terms of that lease ending, if a property owner wishes to remove the tenant at the end of that time, they can do so. So creating an 11-month lease doesn't have any impact on avoiding the provisions of Assembly Bill 141 compared with a 12-month lease. It is only once the tenant goes into a month-to-month rent situation, which again, as noted, they may do from the very start. They may never have a lease agreement, or they may continue month-to-month after a lease agreement ends. And that it's at that point that these notice provisions take effect. So there is no reason to reduce a lease term by 1 month, because at the end of a year-long lease, a tenant can still be asked to move out promptly at the end of that lease. This bill does not apply to that situation in terms of providing an addition of time. And what I'd say to your first question about timelines is many states still have timelines. There are some that are moving towards an end to no cause evictions and towards a just cause, requiring a cause for any removal of a tenant. And it really varies. There are several states that are like Nevada, which essentially tie it to the term. So you'll see in our current statute, essentially, if it's week to week, then you get a week, 7 days. If it's month to month, you get a month or 30 days. There are a number of states, I think 5 other states currently are doing what we're proposing in this bill, which is actually tying the notice to the length of residency in order to provide an additional cushion for longer term, more stable tenants. And then there are also a couple of other states that have 90 or more days of notice in place with certain conditions. There are also some states like Delaware and Georgia that are just a flat 60 days across the board. So just like many other laws across the states, there's a lot of variability, but the provisions of this are well within what has been established in other states across the U.S.
Thank you.
Okay, I'm going to keep working our way down this list. We'll go next to Assemblywoman Bilbray Axelrod.
Thank you, Chair. And, thank you for bringing this bill. I think it's an important conversation that we have. I did just want to say on the record that when I heard about the eviction moratorium and then saw in the news or read in the paper that people were being evicted, I was confused. And I'm a legislator. I thought that there was just a moratorium. So I wanted to ask you a little bit about that declaration that people have to do. What is that involved, and what other states do that or something similar to that?
Sure. Thank you for the question, Bailey Bordelin, for the record. So it has been a complicated year, and the eviction protections have ebbed and flowed through different forms. But what has been pretty consistent throughout most of the year and where we are right now is that the CDC at the federal level issued a guidance that there was an eviction moratorium for those who qualified. And in order to figure out who qualified, tenants who did, so you have fallen behind on rent because of COVID, and that's why you're unable to pay your rent and you have nowhere you could go. Because again, this is a social safety net issue for the community. If we're moving people out of their homes, we don't have capacity and it's not safe to be overcrowding our shelters and our streets. So that declaration system is being used nationally. Governor Sisolak's eviction protections that are also in place right now mirror that concept. So you're qualifying for both. Essentially, you're following the same process. You can use the CDC declaration. You just need to Google it. It's on the CDC's website. It's on the governor's website. It's on Legal Aid's website. And we have done what I think is a tremendous community education outreach campaign to try to reach people, to let them know this is how the eviction protections work. This is what you need to do. But it's been really difficult. So the tenant is supposed to fill out the declaration saying that they qualify for the protections and give it to their landlord. If their landlord moves forward with the eviction anyways by posting that 7-day non-payment of rent notice, summary eviction notice, the tenant is supposed to file that in with their answer with proof of service that they did in fact give it to their landlord in order to get the court process to then pause. So I just saw the additional proposed amendment online this morning, and I want to speak to a little bit why that doesn't work, because what they're proposing is that only people who did file in that declaration to the courts are the people who would have their records sealed. And that's problematic for me because a lot of people didn't know that they needed to do that declaration process. They thought they were protected. And so that's why we're instead going for people who fell through the cracks because they didn't know to do that. They didn't know how the protections worked or how to qualify or how to take those steps. And it's really overwhelming to be in a point of crisis when you're losing your housing in a pandemic. But we do think that just pulling the non-payment of rent eviction records to automatically seal is not going to catch everyone that was affected by the pandemic and was evicted, because these protections at the state and federal level have ebbed and flowed and constantly changed. So there were points in the last year where non-payment of rents weren't going forward, but you could evict someone for no cause using the no cause process because the non-payment of rent lane was marked off. So those people, unfortunately, still won't be automatically helped by this, but because of the process that we did put in place together, Assemblywoman Bilbray Axelrod, anyone can petition to have their records sealed. So our hope is that we'll do the bulk of the people who need it, who fell through the cracks in one click, reduce that burden on the court to do it on a case-by-case basis. And then we'll go back to a community education campaign and try to reach other people and say, hey, if you were affected by COVID, if these circumstances were out of your control, here's what you need to do to get your eviction records sealed. So it's still going to be a lot of work, but I don't think that it's overly broad. That summary eviction process that I spoke to, it does require an opportunity to become current on rent during the 7 days or to leave the property. And if you do either of those two things, you did not end up with a non-payment of rent eviction record. So it is just people who thought that they didn't have to leave the property because there was a moratorium who then were locked out.
Thank you.
Let's go next to Assemblyman Wheeler.
Thank you, Mr. Chair. I've been listening, and while I had some questions, I also need a little clarification here, I guess, from the sponsor. We keep talking about the pandemic, and it's causing this, and this is what's hurting. But I keep looking at the bill, and I don't see anything where this ends when the pandemic is over or when the state of emergency is over. So this goes on into perpetuity, so I don't think it's a pandemic bill. But that's not my questions. My question for Ms. Bordelin or Mr. Barkhold, what I'm seeing in my district is you'll find that a lot of mom and pop type landlords have homes that they use for their, I've got a lot of retired people in my district that they use for their retirement. And in this tight housing market with huge price raises going on right now, when they can't get the rent out of a tenant, and of course there's a moratorium and maybe even rightfully so on evictions right now, they just go ahead and sell the house. When you list a house in my district, for instance, it usually takes about 2 days to sell it, and usually over the asking price at that, and there's a bidding war on it. At least that's the market right now. So it kind of hurts the tenant. What happens then? The house is sold, and all of a sudden it's no longer a rental house. So the tenant, we're pushing the tenant out, and instead of going through a procedure where maybe the landlord could work with the tenant to get that money in, especially with all the programs that we've put in place, for rental assistance. So another problem that I've seen, and I'm wondering how you'll address this, is that if I were renting, let's say, or leasing a home, and the lease comes to an end, and it goes to month, I would now, with this bill in place, go to the tenant and say, okay, if we stay on month to month, I'm going to raise your rent by 40%. Because obviously I now have eviction problems if you don't pay. But if you go into another lease, I will only raise your rent by 20%. So I see problems for the tenants here, where in normal times, when a lease is up, most landlords that I've seen, including myself, have just let the tenant continue on with the current rent, and because they're good tenants. So I see a lot of problems for the tenant here. What do we do about that?
Thank you for the question, Assemblyman Wheeler. This is Assemblyman Watts for the record. You had a few different questions and concerns in there, and I'll try and address as many of them as I can. First, again, I'll just say that so you first asked a question about what's related to the pandemic. I'm glad to clarify that. Section 2 is specifically limited to the declaration of emergency by the governor. So the automatic sealing will only happen for evictions for non-payment of rent that occur while the governor's emergency declaration is in effect. As soon as that ends, the provisions of Section 2 will no longer apply for automatic sealing. So when we talk about the impact of the pandemic on folks, we're really talking about Section 2. The changes to Section 1 are not limited to the pandemic, so that is a permanent application. To your questions, I would need a little bit of clarity about why you'd be looking at rent increases of varying amounts, or why the provisions of this bill would lead a property owner to sell instead of continuing to rent, particularly because, as you said, this applies to good, stable tenants. And again, that notice period does not end the obligation for a renter to pay. So currently, under law right now, if you have a tenant that's lease is ended and you're going month to month, if for any reason you just want to get the property back, then you give them 30 days notice. Under the provisions of this bill, you instead would give them 60 days notice. As was said before, if they find another place to live and they want to move out, then they can let you know and they can move out within the 30 days or less. Just like currently, if somebody has 30 days notice, they can move out sooner than that. Also, they have to pay rent. So they'd have to pay rent for that last month once you give them that notice. Under this, they'd have to pay rent for those last 2 months. And if they do not, you can initiate summary eviction, which has it's a completely different part of statute, a completely different timeline, and you can have that tenant removed within a matter of days.
Okay. Well, the reason that people would sell is because of the housing market right now. If they've got a good steady tenant coming in all the time, they don't have to worry about an eviction, et cetera, where the rent's coming in all the time. A lot of times they'll keep it because that's their retirement income. But if they see a problem coming down the line, in my opinion, then it's easier to sell the house, pay the 9% capital gains on the thing, put the money in the bank. So, or reinvest in something else. Maybe Bitcoin, but that's my reasoning here. And I think this is going to end up charging the tenant more and more as time go on. I know a lot of landlords have relationships with their tenants, for instance, and never raise the rent ever. Even when it goes to month. But now they may look at that and say, I can't afford 2 months without rent. Well, I like this guy. Maybe I ought to just sell this place and get out of here. So I think, I can see both sides, Assemblyman. Thank you for that.
Thank you, Assemblyman Wheeler. And again, Assemblyman Watts, for the record, I appreciate your clarification on that. And of course, want to recognize the positive relationships that many tenants and landlords do have. And I just want to reiterate once again that nothing in any provision of this bill removes a tenant's obligation to pay. So changing the changes in Section 1 of this bill do not create a 30, 60, or 90-day window where a tenant does not have to pay, and therefore creates an additional cost onto the property owner. It simply provides additional notice during which that time the renter must pay or else face the exact same, frankly, expedited eviction process that is on the books in Nevada law right now. So I'm glad to provide that clarification for the record. Thank you again for the question.
Thank you, Assemblyman Watts. We'll continue down the list of questions. We'll go next to Assemblywoman Krasner.
Oh, thank you, Chair Yeager. My question is for Mr. Berchtold from Legal Aid, please. Mr. Berchtold, does this only apply to seniors and individuals with disabilities, or does this apply to anyone? That's my first question, like maybe a family with children.
This would apply to anyone who is a month-to-month tenant, who does not have a written lease agreement, who has been on the property for an extended period of time, would be entitled to the additional notice. So yes, it would apply to seniors, it would apply to disabled, but it would apply to everybody. So families moving who have children and have to relocate and try to keep in the same school district, and that can be incredibly problematic. So yes, it would protect them as well.
Okay, and follow-up, Chair, please.
Please go ahead.
Mr. Berchtold, now I know you said, I think you said this, the Section 1 only applies to non-payment of rent during the pandemic, and then I think you gave a time frame. Is that correct? Could you please clarify that?
Sure, of course. And that's actually Section 2, I think you're talking about, and this is Jim Berchtold for the record. Section 2 is the section that deals with the sealing of the eviction records. And yes, that would only apply to non-payment evictions during the state of emergency. The state of emergency was declared on March 20th, 2020. So it would extend until the governor, until it ends, until the governor says it ends. So any eviction during that period for non-payment of rent would be automatically sealed.
Okay, and then that's it. It doesn't extend into perpetuity. Okay, thank you.
Let's go next to Assemblywoman Hanson.
Good morning, everybody. Thank you, Chair. A couple of questions here. Let me navigate my devices, and you've answered some of my questions, so I kind of keep moving to, well, now I have a different question. Assemblyman Watts, so we've clarified that this applies when tenancy is month to month, and tenancies with a fixed expiration date, they'll not fall under this. So my concern is for landlords that maybe have, you might have a tenant who wants a month to month because of life circumstances, but in order to get the rental that they need, it's only going to be a fixed date. And then they would be kind of forced into a situation to take a property that they might have to break a lease on, because this landlord now is concerned about a month to month, wants a fixed date. Is that an unintended consequence for these tenants now having to go to properties that have more of a lease arrangement rather than a month to month, because now a landlord is shifting due to legislation?
Thank you for the question. Assemblyman Watts for the record. And I'll let others speak to this as well. I think what I would say, my personal opinion is, and I've heard about stories of, there are folks who are serving our country overseas who have properties that they're renting. There are other folks who have properties that they're renting, and they have a planned return date, and they're concerned about how this could affect them. And I've spoken with some of those individuals. And as you've noted, did want to clarify that this does not apply to a lease agreement. So I think usually when a property owner is looking at a date certain that they want to have the property freed up, then they're going to want to seek out a lease agreement. And so, yes, I would say that this would encourage, if a property owner needs to have their property back on a date certain, they would establish a lease so that they would be able to gain control of the property on that date. What we often find is month to month can go on really until there's an issue with the tenant or until the tenant decides to move somewhere else. And again, this only is when there's no issue with the tenant. And the property owner has decided that for whatever reason, and I understand the property owner's rights, whatever reason that they have, that they want to remove the tenant, and whether they want to move in, sell it, get a new tenant, change things around, remodel, they can do any of that. We're just asking that for tenants that they've had a longer term relationship with over a year, that they have up to the additional 30 to 60 days to do that. And again, it may work out where they can find a place even quicker than that, in which case they can move on. And again, and I know I'm repeating myself, but if they do not pay, if they, after that history of having a great relationship, decide they don't want to pay after getting that notice, then they can be removed quickly through summary eviction.
Bailey Bordelin, for the record, I would just add that we would view it as a positive additional consequence if more people were in leases. Leases don't have to last for 1 year, but they do provide some clarity and contractual security for both the landlord and the tenant about how this relationship is going to work. So if more people do choose to renew a lease rather than allow a month to month to just casually occur, I think that's positive, because there's a lot of rights and systems that work better when there is a lease in place. And it wouldn't have to last for a year. You could do 3 months, you could do 6 months, but you'd have some certainty. And with that certainty, each time that date was approaching, you would have a built-in date where you could communicate between the landlord and tenant and say, do we want to plan on this as an exit date, either party, or should we continue to renew? And so that builds in just a little more stability for that contractual relationship.
Chair, if I could just follow up real quick.
Please go ahead.
So yes, and I understand the intent. Your intentions are good. You're trying to accomplish something good, but again, I just am concerned that this legislation is going to force some unintended consequences. The majority, well, I would assume a lot of the mom and pop type rentals. This legislation takes away some of those choices, I think forces those landlords to have to make some decisions that they might want to just wash their hands of this now and not be in a rental space, sell their properties, which in this market reduces the amount of rentals available because, some people do want to live in a single family home. They need a yard, and those are going to be fewer and far between when landlords feel that their choices of how they're going to rent their property as month to month or leases gets more and more narrowed. So just concerned about limiting the rental availability and restricting property rights of the owners. But thank you for your presentation, and I might come back with another question. Thank you.
Okay, we'll go next to Assemblywoman Kasama.
Thank you, Chair, and thank you, Watts, for the Assemblyman Watts for the presentation, and to Jim Burchell and Bailey Bordelin. My question is, one of the questions was asked, and it was clarified that under Section 1 and the proposed amendments here, that this could apply to anybody. And so, but with Jim Burchell's, your overview and your presentation, I heard you using numerous times senior, low-income housing, disabled, not giving people enough time. It could move people to homelessness. But that isn't addressed in this section. So if I understand it correctly, if I have, which is a true example from someone else, that there's an owner of a property who rented his home here, took his job in California, loses his job there, has to come back. He's had the tenant in there for 2 years. They've gone to month, gives them notice. Now he can't move into his property for 90 days. And then he has to, and so this is not a person in his property that falls under senior low-income housing. So now he has to go rent a hotel until the person leaves the property. And that's where I see problem with, because what I'm hearing from everybody is the low income housing, the seniors, the disabled. And I think this bill goes too far, encompassing all. And I do believe that it takes away the right of the owner to take possession of their property again. And I understand these issues here. Maybe I think that we need to look at that more versus making this an all-encompassing bill that throws everybody into the same bucket.
Thank you for expressing that concern, Assemblywoman Kasama. This is Assemblyman Watts for the record. And I know that you have much experience with these issues, so I appreciate that. And I think we do just have some disagreement. I would say that it does place some additional protection for the tenant, but it does not fundamentally restrict the property owner's ability to regain control of their property. And you are correct, this does not just apply to seniors or people with disabilities. It also, as Assemblywoman Krasner asked, would apply to families with children. It would apply to single individuals as well, who also, may be living in a property for a long period of time and not have a plan for where they're going to go next. So, it is in fact broadly applicable to everyone to give that additional notice. And, so that's the response that I have. I don't know if my co-presenters have anything else to add.
I'm not seeing anything from the co-presenters. Assemblywoman Kasama, did you have any other questions?
So the other thing I did want to ask about, at the beginning of your presentation, you quoted 500,000 projected to be evicted. And I believe, where did you get that number from?
Thank you, Assemblyman Watts, for the record. That was a study conducted by the Gwynn Center, and we'd be glad to send that as a follow-up to the members.
So, and I believe that Gwynn study was done at the beginning of the pandemic. Is that correct?
Bailey Bordelin, for the record, it was done twice. The first projection was earlier on in the pandemic. I don't have the exact dates in front of me, but I believe at that point it was over 300,000 Nevadans were projected to be at risk of eviction, and it was increased to over 500,000 evictions in the fall.
So from my observation, I haven't seen an indication of the numbers being that high. I think we'd have to get hard data to see what has actually, what is the projections from people that are faced with these evictions. I know currently now, I know you were talking about the unemployment rates. Right now, it's 8.2% as of December 2020, and that's from the Western Information Office, the Bureau of Labor Statistics. Our unemployment is now at that rate, and I know you were quoting higher rates. And so I just want to make sure that we're dealing with the most current information when we, provide this information for people to make informed decisions.
Thank you for that, Assemblywoman Kasama. Assemblywoman Watts, for the record. I appreciate that. And again, this is not people that had eviction processes in place. This is given the economic consequences of the pandemic, renters who would be at risk for eviction. And one of the reasons that those numbers haven't been so high is because of the protections that have been put in place to date during the pandemic crisis. And yes, our unemployment rate has gone down from hitting truly stunning record-setting highs at the pandemic. Although I will note that it is still among the highest of any state in the country. I don't have the latest figures in front of me, but I would be surprised if we were not still in the top 5 states in the country for unemployment.
Okay, thank you. Members, we've been going for about an hour. I've got about 15 more minutes I want to spend on question and answers, and then I'm going to go to testimony because we have, as you might imagine, quite a few folks who'd like to express their opinion on this bill. So I've got a couple more people in the queue right now, but just keep in mind, members, if you can keep your questions concise, and our presenters, if you can keep your answers concise, we'll be able to get through more questions in the next 15 minutes. So next up, I have Assemblywoman Hardy and then Assemblywoman Marzola. So please go ahead, Assemblywoman Hardy.
Thank you, Chair.
And thank you to all of you here presenting this. I think we've kind of demonstrated in talking about this, the eviction process in general can be very confusing for both landlords and tenants. So my question is, in section 1, using this tiered approach, if you have a week-to-week, if you're a tenancy at will, if it's periodic tenancy, then there's all these different, if it's 7, 3 years, up to 1 year to 3 years, and more than this year, then you've got all these different extensions. Do we see this as possibly being even more confusing for landlords and tenants?
Thank you for that question. Assemblyman Watts, for the record. One of the things that we're doing is actually trying to simplify so that instead of based on the term and other things, we're trying to streamline this. So across the board, for any tenancy that is not covered under a lease agreement, it would be 30 days if less than a year, 60 days if between 1 and 3 years, and 90 days if more than 3 years. So I understand that Chapter 40 has a lot of pieces to it. There's even been a discussion about probably the need to clean up the statute so it's easier to understand, and that's a separate conversation for another day. But I actually believe that this would add some additional stability and clarity. It is a change, of course, but I think the communicating the change could be fairly clear.
Okay, thank you. Just one quick question to follow up with that, just a short one.
Go ahead.
Do I understand that as far as like seniors, do they already get an additional 30 days? So that would be on top of any of these days.
Thank you for the question. Assemblyman Watts, for the record, yes, there is a provision specifically for seniors and disabled individuals to request an additional 30 days. And that portion of the statute currently remains. Again, that requires affirmative action and does not capture families and other people. So what we're trying to do is establish a time frame that is specifically for tenants that have long-term, stable, positive relationships, for them to have the additional notice without having to go through a process to request it. Legal aid could also describe this process a little bit better and how it works in practice.
Thank you.
Okay, Assemblywoman Marzola has indicated her questions have been answered already. Are there other members that would like to ask a question? If you could raise your hand. I see Assemblyman O'Neill, so we're going to go to him in just a moment, but let me look at everyone on the screen. Anyone else that has a question? If so, could you raise your hand so I can hopefully note that you have a question? Assemblyman O'Neill, it might just be you, so please go ahead and ask your question, then we'll see if there are any others.
Thank you, Chair. And actually, I had several questions. I'm just going to make a statement. I think that I appreciate what Assemblyman Watts and the rest are trying to do with this, but I think Ms. Bordelon and I may have agreed. Maybe the solution to this whole discussion today is to scrap the bill and require that all rentals have to have contracts or leases, and that will solve the problem. Because it gets confusing otherwise. We're talking about lease, no lease. Person was on a lease, then they go off the lease. Now they're qualified for this tiered system of how long they are there. Just maintain that they have to have leases, period. It's a contract. It protects both sides. The other part is, I do disagree with Section 2 on sealing the records. I think there has to be more of an effort. I think the landlords, the owners of the property, have a right to know that the person was evicted. So it's more of a statement, just to be short. Thank you for the time, Mr. Chair.
Thank you, Assemblyman O'Neill. Certainly welcome to broach that topic with the sponsors. I don't imagine they're going to be willing to take that suggestion, but would encourage you to ask them offline. Any other questions for our presenters today? Okay, this is last call for questions. I don't see, I see one more. Assemblywoman Kasama, we're going to give you the last word, but please make sure it's a question and not a statement.
Thank you very much, Chair. I do have a question for section 2 under the sealing of the records for COVID. So in this broad sealing of the records, if somebody was receiving rental assistance, pandemic money, stimulus checks, even had their job, and they had the money and they chose not to make the payments to the landlord, they would still get their record sealed under this case. Is that correct?
Bailey Bordelon for the record, unless the Assemblyman wants it. Saw you on mute.
Go ahead, and I'll offer a brief follow-up after you're done.
Okay, sure. I do not believe that they would have an eviction record. So it's a bit of a fine hair to split, but if someone were to have the ability to pay and choose not to, I don't believe they would be evicted for a non-payment of rent eviction because of that 7-day process where somebody has a legal opportunity to become current or leave the property. And if you do one of those two things, you would not get to the point where an eviction record has been created.
So in that,
sorry, if I may briefly just follow up. Yes, so specifically it would have to apply to someone who had the resources to pay rent and their other obligations, chose not to do that, chose not to respond, not to get current, and not to leave a property, and to let an eviction be entered in onto their record. In that hypothetical case, if it occurred during this declaration of emergency, it would be included. However, and I know you'll hear later from opponents about their suggestion for automatic sealing. The issue is, we know, I think all of us here know, how long people have struggled to get access to their unemployment benefits. We know how quickly rental assistance programs have been swallowed up. Frankly, we just don't have the resources to help everyone, to help tenants and I mean people, Nevada families, catch up on all of their bills and their needs so that they can provide food, so they can provide housing, so that they can pay their other critical bills and meet their basic needs. And the resources just haven't been sufficient in terms of unemployment that's fluctuated in amount, that sometimes has taken months to receive, in terms of payments from the federal government that have totaled in less than $2,000 over the course of a year. So we certainly need more resources to help property owners and renters, and again, just all of these folks being Nevada families, help make them whole. We just want to make sure that for the folks that have suffered those consequences, that they don't slip through the cracks and that they're able to access housing again.
and Assemblyman Watts, I completely agree with you. There are a lot of people out there struggling. We need to get these resources moving to them. I know there's a delay in the resources coming to them, and that is an issue. But based on your own comment, and my question was somebody that had the ability to pay, they would be protected under the sealing of the eviction records, and that is something I couldn't agree with.
Thank you for that, Assemblyman Watts. For the record, I just want to briefly say this is a discussion and debate that I've had with others as well, and I appreciate that. I just simply will. I'll just be very blunt. I respectfully disagree, and I would rather protect that hypothetical person who, again, not only chose not to pay, but then chose to allow an eviction record to happen instead of vacating or instead of getting current with the rent. I would rather that hypothetical person or handful of people be covered, as well as all the people that simply have been overwhelmed by this crisis and didn't know that they needed to file a declaration in order to access these protections. I want to make sure that we cover everybody who's not who slips through the cracks, even if that does cover a handful of bad actors. And as Ms. Bordelon said, many folks, if they're actually being cleverly malicious in having excessive resources that they're trying to hold and don't have other obligations that they're using it for, would likely find a way to avoid getting the eviction record in the first place.
If
I
we
believe
could, in
we-
defiance of, sorry.
I was just going to say, I believe we need a carve out for that, but I respectfully agree we can disagree on that.
Bailey Bordelin, for the record, apologies to the chair for not being brief. The only thing I want to add to that piece is, if from my conversations with the judiciary, without speaking for them, but I will tell you that our conversations have been, it doesn't make sense from a policy position to go through these on a case-by-case basis, because people do have the ability to motion to have their records sealed. But what we are up against on March 31st, in less than a month, is that the state and federal eviction protections are currently set to lift, and we are going to have a tsunami of court proceedings that have not been occurring by and large for the last year. And so how do we want to use those limited court resources? Because we do not have capacity to have hearings or to review those on a case-by-case basis, when we're also going to now have all of the evictions that have been stayed because of the pandemic. And so from a systems operations standpoint, it just makes more sense to click a button and cover these people than to require the burden and the community education and the court resources to do it otherwise.
Some of them say very quickly, Mr. Chair, is again, I offer to, as well as to the other folks that I've discussed that have concerns with this bill, if there is a way to preserve the automatic process that we're talking about, to preserve the court's resources, as well as to find some way to carve that out in a way that the court can operationalize, I'm welcome to those suggestions.
Thank you. Appreciate that. Look forward to visiting with you more.
Okay, great. So we're going to leave it there in terms of the presentation, questions and answers. Members, if you have additional questions, would encourage you to seek out Assemblyman Watts or his two co-presenters. And I want to thank the three of you for presenting. I'll ask you to sit tight while we get through some testimony, and then there'll be time for some concluding remarks. And just want to give everyone kind of a lay of the land of where we're going to go from here. Given the amount of time we've had, I'm planning on taking about 45 minutes, up to 45 minutes of supportive testimony, about 45 minutes of opposition, and then I guess we'll see if there's any neutral. There may not be on this bill. So everyone who's going to be presenting, if you're on the phone or you're in the Zoom in support, would ask you to try to keep your comments to 2 minutes, and it's perfectly fine to say, I agree with what's been stated, so we can get to as many folks as possible. So now I'm going to open testimony in support. We do have a few individuals with us on the Zoom today that are going to offer supportive testimony, and I think we have 3 of them. I'll just call them out in order so we can do this in an orderly fashion. So I wanted to start with Emily Paulson from the Nevada Homeless Alliance. If you are joining us, okay, I see that you've turned your camera on, so please go ahead with your supportive testimony.
Good morning. For the record, my name is Emily Paulson, and I serve as the Executive Director of the Nevada Homeless Alliance and as the Chair of the Policy Council on Homelessness. We urge you to support AB 141. A single eviction record can make it extremely difficult to secure new housing and puts households at risk of homelessness. Eviction records are also a common barrier to people exiting homelessness. We hear consistently from homeless service providers the difficulty they have in rehousing households with an eviction record. As the presenters of the bill have shared, thousands of Nevadan households have slipped through the cracks of eviction protections, and thousands more are at further risk when the eviction moratoria expires at the end of this month because of the backlog in the provision of rental assistance. In particular, in Clark County alone, as of 2 weeks ago, there were over 11,000 households waiting for assistance. Automatically sealing court records of eviction that occur while our state is under emergency declaration for COVID-19 will ensure these Nevadan renters are not penalized from the unavoidable economic consequences of the pandemic and do not become further at risk of homelessness. Pre-pandemic, Nevada had the 4th highest rate of unsheltered homelessness in the nation due to a variety of factors, including inadequate investment into affordable housing development. We simply do not have the social service infrastructure in place to respond to a wave of households becoming homeless. And if we do not take steps to help tenants get back on their feet through reasonable policy as proposed in this bill, the consequences it will have will be great will have great human, social, and fiscal costs. Excuse me. Thank you.
Thank you for providing your testimony, Ms. Paulson. We appreciate that. I want to go next to Mr. Quentin Savoy. Hopefully I pronounced your name right, sir. Try my best. So he's with Make It Work Nevada. He's with us on the Zoom as well. So please go ahead and provide your testimony.
Chair Yeager, you got the name perfectly right. So thank you very, very much. Good morning. And good morning to honorable members of the committee. I'm Quentin Savoy, the Deputy Director at Make It Work Nevada. We're also part of the Nevada Housing Justice Alliance. I'm at my organization specifically. We work alongside Black women and Black families to help change policy in the areas of economic, racial, and reproductive justice. And AB 141 allows legislators an opportunity to do something about each of those fights, and it demands our urgent attention. When current protections expire at the end of March, hundreds of thousands of Nevadans will be threatened with eviction. We know that statewide women of color lead the households that will make up many of these evictions. These are the same women that have been counted amongst the 5.4 million jobs that, according to the Center for American Progress, have been lost due to the pandemic. Nationally, women of color, Black women specifically, are evicted at exceptionally higher rates than any other group of people. When Black women are evicted, it drives them further into neighborhoods that lack adequate resources to raise their families. That is if they are able to find housing that's affordable, because Black women are still paid significantly less than their colleagues for doing the exact same work. According to sociologist Matthew Desmond, when a Black mother with an eviction on her record moves, it is often to a neighborhood that is significantly further away from basic amenities like a park, a grocery store, or a healthcare clinic. All of these things layered on top of the other proves this is more than just a housing issue. It's an economic justice issue. It's a racial justice issue. It's a reproductive justice issue. At its core, AB 141 is about giving families a little wiggle room as we all navigate the landscape of these uncertain times. We don't seek to villainize or devastate the industry for landlords or property managers. We just ask for policy that considers the full humanity of our community members and shakes the ironclad grip that this industry has on our public policy in this state. We urge bipartisan support for AB 141 to protect Nevadan families. Thank you for your time today.
Thank you for your testimony, Mr. Savoy. I like saying your name, by the way. It's nice to pronounce. The last supporter we have on the Zoom with us is Mr. Jim Sullivan from the Culinary Union. Mr. Sullivan, welcome to the Assembly Judiciary Committee, and please provide your testimony.
Good morning, Chairman Yeager and committee. My name is Jim Sullivan, and I'm here representing the Culinary Workers Union Local 226. This pandemic has hit culinary union members and their families incredibly hard. While hospitality workers are slowly returning to work, tens of thousands of workers are still unemployed and struggling with housing insecurity. Since last March, the Culinary Union has worked with our Housing Fund and other organizations to keep workers in their homes. Unfortunately, there are still too many Nevadans who have lost their home during this pandemic. Sealing eviction records that were created during the pandemic and extending the timeline for no-cause evictions based on how long a resident has lived there are common sense measures that will prevent further housing insecurity. In the middle of this pandemic, working families and people of color have been disproportionately impacted by housing insecurity, and AB 141 is a step in the right direction towards rectifying that. The Culinary Union believes that everyone deserves to be treated with dignity and that housing is a human right. Nevadans should not have to decide between having food on the table or having a roof over their head. This bill is the right thing to do, and the Culinary Union fully supports AB 141. Thank you.
Thank you for your testimony, Mr. Sullivan. I don't believe we have anybody else on the Zoom with us, but I'm pretty sure we have some folks on the phone who would like to offer testimony and support. BPS, could we go to the phone to see who might be there and ask the first caller to provide testimony?
Yes, Chair. To testify in support of Bill AB 141, press *9 now to take your place in the queue. With the caller with the last 3 digits of 130, please slowly state and then spell your name for the record. You will have 2 minutes and may begin now.
Good morning, Chair and members of the committee. For the record, my name is Christine Saunders. That's CHRISTINESAUNDERS, and I'm the Policy Director with Progressive Leadership Alliance Nevada, here in support of AB 141. First, we want to thank Assemblyman Watts for bringing this important legislation forward. This morning, you will hear stories of the hundreds of thousands of Nevadans who have faced unemployment and housing instability because of COVID-19. AB 141 is a common sense solution to ensure that these Nevadans are able to come out of this pandemic whole and are able to thrive in dignity. We ask for your support. Thank you.
Thank you for your testimony, Ms. Saunders. BPS, let's take the next caller, please.
With the caller with the last three digits of 540, please slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair Yeager, members of the committee. My name is Serena Evans, SERENAEVANS, and I'm the policy specialist for the Nevada Coalition to End Domestic and Sexual Violence. And we're here today in strong support of AB 141. Like many victim survivors of domestic and sexual violence are experiencing housing insecurities because of the COVID-19 pandemic. In about 99% of abusive relationships, the victim survivors experience some form of financial abuse. This includes purposely sabotaging an individual's credit and employment. Prior to the pandemic, victim survivors noted that access to affordable and safe housing was one of the biggest barriers for leaving an abusive relationship, and the financial abuse that they incurred negatively affected their ability to obtain new safe housing options. The pandemic has only exacerbated this problem with the additional burden of now having a no-pay eviction on their record. We know that without being able to obtain safe and affordable housing, victim survivors are more likely to stay with an abuser, increasing their risk of homicide, or they have the increased risk of becoming homeless, which significantly increases their risk for future domestic and sexual violence victimization. Sealing records of evictions for no pay during the pandemic crisis will decrease barriers for victim survivors and their families in accessing safe housing. We are also in favor of an extended notice period for no-cause evictions, as all individuals deserve a reasonable amount of time to find adequate and safe housing. Thank you.
Thank you for your testimony, Ms. Evans. BPS, let's take the next caller.
With a caller with the last three digits of 181, please slowly state and then spell your name for the record. You will have 2 minutes and may begin now.
Good morning, members of the Judiciary Committee and Chairman Yeager. My name is Lalo Montoya, LALOMONTOYA, and I serve as the Housing Justice Organizer for Make the Road Nevada, and we are also a part of the Nevada Housing Justice Alliance. I am speaking in support of AB 141. We are a member-led nonprofit organization fighting to improve the quality of life of all immigrants and working families in Nevada. With the end of the eviction moratorium looming, thousands of households are at risk of eviction. The CDC eviction moratorium does not kick in automatically for renters. It leaves tenants who are struggling financially during this ongoing economic crisis, grasping for avenues to protect themselves from eviction despite the current eviction moratoriums. Additionally, eviction records do present barriers to obtaining long-term housing for those families who have been disproportionately impacted by COVID-19. AB 41 is needed. It's needed now. We need immediate protections now. It will provide tenants with just a little more time to secure new housing, and it's going to lessen the collateral damage that's being caused by these no-cause eviction records. As we approach the 1-year anniversary of the stay-at-home orders, I urge you to pass AB 141 so that Nevadans can stay safe at home. Thank you.
Thank you for your testimony, Mr. Montoya. BPS, let's take the next caller, please.
If you have just joined the meeting, we are currently in testimony for support of AB 141. If you'd like to testify in support, please press *9 now to take your place in the queue. With the caller with the last three digits of 419, please slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Hello. Thank you, Chair Yeager and members of the committee. I am Benjamin Challoner. That's BenjaminChallonor, and I am the Policy Director for Faith in Action Nevada. We are here in strong support of Assemblywoman Watts' AB 141 as it looks to protect those who have been most affected by the COVID-19 pandemic. I will keep my remarks brief since a lot of what I wanted to say has been said, and I want to make sure that those affected community members have time to speak. This bill looks to help not only those who fell through the cracks, but those who have been left behind in their time of need. And that's important to know. They've been left behind by the state of Nevada. Just one Nevadan at risk of eviction due to the pandemic is too much. And the fact that it's in the hundreds of thousands and can be up to 500,000 should be something that we must act on now. Thank you so much for taking your attention at this bill. We need to make sure we pass this. Thank you for your time.
Thank you for your testimony, Mr. Challenor. BPS, are there other callers in support?
Yes, with a caller with the last 3 digits of 161, please slowly state and then spell your name for the record. You will have 2 minutes and we begin now.
Hello, thank you to the committee. For the record, my name is Carla Ramirez, Karla Ramirez. I am an organizer with Planned Parenthood and a community member. Planned Parenthood Votes Nevada is in favor of AB 141 because housing is health care, and no person should be left without a roof over their head for any period of time. Losing housing is one of the greatest threats to reproductive health and rights because it jeopardizes a person's privacy and access to critical reproductive health care services, as well as impacts a person's right to make decisions about their bodies. It's hard to imagine that a person could prioritize their health while houseless, and the pandemic has shown us how true that is. Sealing eviction records and ensuring that people have an adequate amount of time to find stable housing is crucial for a healthy Nevada. We urge you to support Nevada families and support AB 141. Thank you.
Thank you so much for your testimony, Ms. Ramirez. We appreciate it. BPS, let's take the next caller, please.
With a caller with the last 3 digits of 618, please slowly state and then spell your name for the record. You will have 2 minutes and may begin now.
My apologies. I'll wait for neutral or opposing. Thank you.
BPS, let's go to the next caller in support, please.
With a caller with the last 3 digits of 199, please slowly state and then spell your name for the record. You will have 2 minutes and may begin now.
Good morning, Chair and members of the committee. My name is Tess Opferman, that's spelled Opserman, speaking on behalf of the Nevada Women's Lobby. One of the top priorities of the Nevada Women's Lobby is housing security. We work hard to support legislation that ensures women and families are able to maintain affordable and stable housing, something that has been made even more difficult by the current pandemic and the incredibly high rates of unemployment that has disproportionately affected women and women of color. These are unprecedented times, and sealing eviction records that took place during COVID-19 is a fair and logical way to protect those that have lost their jobs or have income insecurity. The second part of this bill, allowing 30, 60, or 90 days, merely provides a cushion to those tenants to find housing they can afford while still paying rent throughout that time frame to their current landlords. This is fair and reasonable legislation. Thank you to Assemblyman Watts for bringing this bill forward, and we thank the committee for your time this morning.
Thank you for your testimony, Ms. Opferman. BPS, do we have other callers in support?
With a caller with the last 3 digits of 023, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Hello, my name is Vera Moore. I am the director of True Beginnings and a member of Plan Action. We support the AB 141. True Beginnings assists formerly incarcerated women with overcoming barriers that prevent them from reclaiming their rightful place in American society. I am a peer support member, but bigger than that, I am a formerly incarcerated woman. It took me 9 months to find my house. And if I were to lose my housing at this point, where would I go? I assist women at this very moment who have lost employment. And as we know, employment is the #1 barrier to housing, and criminal history is the #1 barrier to employment. So we will be affecting our entire community. Allowing this bill to pass would give the women, the people in our community that are formerly incarcerated, the ability to become proactive or remain proactive and key players within our community and not face that additional barrier of eviction, even though they have other barriers to overcome. Thank you.
Thank you for your testimony, Ms. Moore. BPS, let's take the next caller, please.
With the caller with the last three digits of 601, please slowly state and spell your name for the record. You will have 2 minutes and we begin now.
Good morning. My name is Barbara Paulson, and I'm here representing Nevadans for the common good. All of us are looking forward to the time that the pandemic comes to an end and we can start moving forward with our lives. Thousands of Nevadas are currently waiting that in fear and instability, wondering what is going to happen when this ends and evictions begin. Sealing records for non-payment of rent evictions will enable thousands of these people to rebuild and move forward with their lives, which is what we want for every resident of our state. Failing to provide this protection only extends the misery of uncertainty and instability for many, limiting their ability to regain stability and again become an active, productive member of our society. Nevadans for the Common Good strongly urges you to pass AB 141. We support both components of the bill. Thank you for your time.
Thank you for your testimony, Ms. Paulson. BPS, let's take the next caller, please.
With the caller with the last three digits of 023, please slowly state and then spell your name for the record. You will have 2 minutes and we begin now.
Thank you, Chair. Thank you, everyone. My name is Dr. Jeffrey Tompkins. It's Jeffery. The last name is Thom, M as in Mary, P as in Paul, Kins. I'm the founder and executive director for JET Foundation, a local nonprofit, in addition to the Nevada chapter president of the National Nonprofit Minority Association, and strong support of the bill. Being a person that was personally affected and forced out of my home after 8 years, and not having a lease for 6 of those years. Last year, myself being, having my cancer relapse and being a single father, in addition to working in the community, coming home to 3 separate eviction notices on my door and not having the resources to be able to combat that, I definitely am in favor of this bill. I was fortunately able to find housing, but a lot of people would not be able to do so. And this bill definitely helps people by sealing those records and not having those barriers to moving forward. So as I stated, I am in favor of this bill and definitely thank the bill for being drafted and moving forward. Thank you for your time.
Thank you for your testimony, Dr. Tompkins. BPS, let's take the next caller, please.
With a caller with the last three digits of 736, please slowly state and then spell your name for the record. You will have 2 minutes and may begin now. Caller with the last three digits of 736, press *6 to unmute yourself and then slowly state and spell your name for the record. Caller 736, you may begin now. All right, we're going to move on to the next one. We'll come back to that. With the caller with the last three digits of 152, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good morning. My name is Cecilia Diaz. I'm the COVID-19 Benefits Connector at Arriba Las Vegas Worker Center. That's CECILIADIAZ. My comment in favor of AB 141 comes on behalf of thousands of our members and members of the community who are suffering due to evictions during COVID. Some who are already on the streets because they've been evicted or are currently facing and battling eviction threats. We are entering into a new phase of the COVID crisis, which is homelessness and eviction. The pandemic has already taken lives, it's taken jobs, and now it's taking homes as well. And people are struggling to inform themselves on how to exercise their rights against evictions when they're faced with unlawful threats of eviction, which are real, and even discriminatory behavior from their landlords, which is also very, very real. As several of our members have shared via written testimony submitted to this committee, an eviction order on a person's record is punitive. It's a source of shaming and judgment. The COVID pandemic has already wreaked a lot of havoc. We all know that. And economic and health hardship due to COVID-19 are sometimes out of our control. And those who are hurting most due to the pandemic have done everything that they can to help themselves, but they're still struggling. There are millions of dollars in rental assistance funding that hasn't been dispersed. Many of our members who have submitted testimony to this committee, along with tens of thousands of Nevadans who've submitted applications for CHAP fundings, remain unresolved and unhelped. Some applications have been pending since November of last year. It's clear that the funds are there, but with the volume of people needing help, nobody's getting the assistance swiftly in the manner that they need it. On behalf of Arriba Las Vegas Worker Center, I strongly urge you to act swiftly in support of AB 141 to ensure that our communities can recover and that they can rebuild after COVID-19. Thank you.
Thank you for your testimony, Ms. Diaz. BPS, next caller, please.
If you have just been admitted to the meeting, we are in testimony in support of Bill AB 141. If you'd like to submit testimony in support of the bill, press *9 now to take your place in the queue. Would the caller with the last 3 digits of 736 please slowly state and then spell your name for the record? You will have 2 minutes and may begin now. Would the caller with the last 3 digits of 656 please slowly state and then spell your name for the record? You will have 2 minutes and may begin now.
Buenos días.
Hello, thank you. Hello? Hello, thank you. This is Will Pregman, W-I-L-L-P like Peter, R-E-G-M-A-N, representing Battleborn Progress. We're rising in strong support today of AB 141 to give those experiencing housing insecurity in Nevada hope of securing new, stable housing and prevent landlords from abusing no-cause evictions to swiftly kick people out of their homes. During this pandemic, thousands of Nevadans have lost jobs and income due to no fault of their own. The governor and the CDC's eviction moratoriums have been a vital asset to keeping families in their homes this past year. However, these protections are set to expire March 31st, and even still, many families have fallen through the cracks. Today, nearly 500,000 renters in Nevada are vulnerable to eviction once these benefits expire at the end of the month, especially amongst communities of color who make up a disproportionate number of Nevada renters. AB 141 would help prevent an eviction crisis. Sealing records for those who are evicted during a state of emergency will avoid ruining that person's rental or credit history. Having an eviction on record makes it more difficult for that person to ever have hope of finding new housing or be able to own a home. Second, extending the notice timeline for no-cause evictions, which can be initiated by a landlord at no fault of the tenant, will at least give those families time to pack, sort out their affairs, and secure new housing before being removed from the property. We should not let unscrupulous landlords rely on a loophole to kick people out on the streets during this pandemic, and we should let renters who are already economically vulnerable move forward with their lives without the storm cloud of an eviction hanging over them forever. Please put Nevada families' interests first and pass AB 141 before we face an out-of-control eviction crisis. Thank you very much.
Thank you, Mr. Pregman. And BPS, I'm not sure if we had our 736 caller on that line as well. Maybe we could check to see if she's been able to unmute.
Thank you, Chair. I will try one more time with her or him. Caller with the last 3 digits of 736. Please slowly state and then spell your name. For the record, you will have 2 minutes and may begin now.
Buenos días, miembros del Comité Judicial y Chairman Yeager. Yo soy Arely Sánchez, A-R-E-L-I-S-A-N-C-H-I-Z. Vivo en Las Vegas y soy madre de familia. Estoy testificando en apoyo de AB 141. En esta pandemia me he dado cuenta de que las leyes de vivienda son injustas para los inquilinos. Tenemos muy poca protección. La pandemia nos impactó económicamente y por recortes de horas perdí un poco de trabajo. Estamos en riesgo de desalojo. Mi familia y yo vivimos en nuestro apartamento actual por los últimos 2 años. AB141 me hubiera ayudado a un mal récord de desalojo en el pasado injustificadamente. Desde eso pasó hace 3 años. Me ha sido difícil superarlo hoy en día, al igual que a mi niña, viviendo en nuestro apartamento actual. No me he recuperado del todo. Si hubiera tenido yo los 30 días para encontrar un nuevo hogar, no hubiéramos quedado completamente en la calle. Perdí mi carro, mis muebles, y fue una gran pérdida económica. Para nuestros representantes elegidos, les pido por favor, pónganse en el lugar de quienes gobiernan, sean vulnerables hacia las personas que dicen representar y piensen en todas las casas destruidas como resultado de desalojo. Les pido por favor que pasen la propuesta AB141 para que nuestras familias tengan el tiempo suficiente para encontrar un nuevo hogar. Muchas gracias por su atención y nada más quiero poner una notita que se me hace pues muy injusto que mi hijo, el que es mayor de edad 22 años, tenga que apoyarme de tal manera a tener este apartamento. Gracias y muy amable.
Gracias, Señorita Sanchez. And members who don't speak Spanish, we will have that translated for you so you were able to understand what was being said. So look for that in the near future. I'll make sure to get that to you. BPS, do we have any other callers in the support position?
Yes, we do. With the caller with the last 3 digits of 634, please slowly state and then spell your name for the record. You will have 2 minutes and may begin now. Caller with the last 3 digits of 634, please press *6 now to unmute yourself and begin speaking.
Is Lorinda Barrett. Good morning, and thank you for the opportunity. My name is Lorinda Barrett, and I am an ambassador with Make It Work Nevada. I just wanted to quickly speak in support of AB 141. I am currently an unemployed mother of a 5-year-old who is, like so many others, in danger of being evicted at the end of the moratoriums. So I do believe that this would be beneficial to all Nevadans of past and help those that are unable to pay their rent due to unemployment to stay in their homes. Thank you.
Thank you for your testimony, Ms. Barrett. BPS, are there other callers in support?
Yes, Chair. With the caller with the last 3 digits of 850, please slowly state and then spell your name for the record. You will have 2 minutes and may begin now.
Good morning, and thank you, Chair and Committee. For the record, my name is Taylor Dixon, TaylorDixon. I am the MSW Policy Intern with the ACLU of Nevada, and we are here in support of AB 141. The ACLU of Nevada recognizes that the eviction crisis happening in this state is a racial, social, and economic issue. As Assemblyman Watts stated in his presentation, 500,000 Nevadans are at risk for eviction, with 2/3 of the renters being people of color. These communities have experienced systemic economic and social burdens that have pushed homeownership out of their reach for decades. Data from the U.S. Census Bureau shows us that Black Americans represent 13% of this nation's population and make up 21% of all renters. However, they are the receivers of 36% of all evictions. Black renters have evictions filed at them at 2 times the rate as white renters, and this is just the tip of the iceberg. Prior to the COVID-19 pandemic, our communities of color had yet to recover at the same level the white communities have in the 2008 economic crisis. Poverty in these populations has continued to increase from the years 2007 to 2018, with 2018 rates higher than that of the Great Recession. While poverty in white communities has steadily decreased, African American communities maintain poverty rates greater than 20%. Already at an economic deficit, faced with higher COVID-19 mortality rates, and now experiencing a risk of eviction that will tarnish every opportunity for housing for the rest of their lives, communities of color are facing further oppression.
AB 141 does the bare minimum for these vulnerable populations. In the midst of a pandemic that has already devastated our communities of color, protecting their right to shelter and facilitating an environment that does not discriminate against them based on evictions during this time is essential. The ACLU supports tenants' rights and supports AB 141. Thank you for your time.
Thank you for your testimony, Ms. Dixon. And would you please let Ms. Wellborn know that we all wish her a happy birthday? BPS, could we go to the next caller, please?
Yes, we are currently in testimony for support of Bill AB 141. If you've just joined the meeting, please press *9 now to raise your hand and take your place into the queue. Would the caller with the last 3 digits of 272 please slowly state and then spell your name for the record? You will have 2 minutes and may begin now.
Good morning and thank you. My name is Ethan Cullings, ETHANCULLINS. Thank you, Mr. Chair and members of the committee. In the interest of time and not wanting to take away from the voices of those directly impacted, I simply want to echo and agree with what has previously been stated. Both sections of this bill protect Nevadans who would be facing evictions through no fault of their own. I encourage you to support both sections of AB 141. Thank you.
Thank you for your testimony, Mr. Cullins. BPS, let's go to the next caller, please.
Would the caller with the last 3 digits of 653 please slowly state and then spell your name for the record? You will have 2 minutes and we begin now. Caller with the last 3 digits of 653, please press *6 to unmute yourself and begin your testimony.
Good Thursday morning. Could you all hear me?
Yes, we can.
Good morning, Chairman Yeager and the committee. This is Dora Martinez, and I am here with the Nevada Disability Peer Action Coalition, and I ditto the callers before me. I just want to put a component in there that there are people with disability who are going through this hardship. And as you all know, the people with disability are on a fixed income. So this would really benefit people with disability. And I thank you so much. And I'm sorry I had a hard time. I was trying to register and it just caught me off guard, the reCAPTCHA. But thank you very much and have a great Thursday.
Thank you for your testimony, Ms. Martinez, and we appreciate your persistence with the technology. BPS, are there other callers in support?
Chair, there are no more callers in support of the bill.
Thank you, BPS. Committee members, I wanted to note for you that we did have the one caller who gave testimony in Spanish. I believe that the testimony has been translated in English and it is up on Nellis as an exhibit, so you can find that there. And I did also want to note for members of the committee and members of the public that there are a number of letters in support that were submitted in writing, so those are available on Nellis as well. There are a few in opposition as well, but just wanted to make sure that we all knew that. So at this time, I'm going to close testimony in support, and I'm now going to open it up for testimony in opposition. And how we're going to do this, committee, is I have 5 folks that are with us on the Zoom call who are going to provide opposition testimony, and we'll have a chance to ask them some questions if you have them. And then after that, we'll go to the phone lines. So I have with us Ms. Mackenzie Warren, Ms. Susie Vasquez, Ms. Tiffany Banks, Mr. Dave Tina, and Mr. David Daslich. So we're going to give them all an opportunity to make their opposition give their opposition testimony, and then we'll take questions. So Ms. Warren, I imagine we'll start with you. Welcome to the Assembly Judiciary Committee, and please provide your testimony.
Thank you, Chair Yeager and Chair Nguyen, and distinguished members of the Assembly Judiciary. Mackenzie Warren on behalf of the Nevada State Apartment Association. The Apartment Association stands in opposition today on Assembly Bill 141. We would, of course, like to acknowledge the sponsor, Assemblyman Watts, for spending what amounts to now hours of work with us and the Nevada Realtors to try and reach consensus. We will continue that work. Together, the Apartment Association and Realtors have submitted an amendment for your consideration. And Section 1 of our amendment retains that 30-day notice period in current law. Section 2 proposes that automatic sealing of non-payment evictions shall pertain to those tenants impacted by COVID-19 and covered under the CDC declaration. Turning to Section 1, it's critical to point out that Section 1 of AB 141 is not related to COVID. And as we've heard this morning, a 30, 60, or 90-day tiered notice period will make Nevada an outlier. We view the extension of these notice provisions as reactionary to the pandemic. And as an industry, we have been under an eviction moratorium for nearly a year. And we strongly feel that now is not the time to tinker or interfere with current law. These extensions will have a devastating blow on Nevada's scarce short-term housing inventory and affordability. A few reasons why. So first, from a practical standpoint, extending an eviction by 30 days, 2 months, or 3 months, unfortunately only prolongs the inevitable. Our real experience tells us that most tenants do not engage in the process until the eve of a lockout, until that notice is taped on their door. And it's usually at that moment that tenants then engage and spring to action. And while the thinking is well intended by the sponsor that by giving people 2 or 3 more months will help, in fact, when an eviction is set to occur, we've reached an impasse. Allowing the tenant to remain in a unit or rental home only means that the young person eager to get out of mom and dad's house, or that single mom with 2 kids who found the perfect unit right in her price range, it's next to her work, next to her kids' school, well, she can't move in because the eviction process will be stalled in some instances. Second, AB 141 seeks to uproot short-term rental options, those weekly and month-to-month situations that are essential to a variety of people. We're talking about high wealth folks, for those looking for a quick and nimble living situation, low income individuals, people who are in a violent situation and need a change, or those just looking for a general transition. Tenants elect this rental option that provides the flexibility and the ability to terminate quickly. And requiring a landlord to provide this much notice will force landlords to reevaluate offering short-term rental housing at all. And hearing today many times that AB 141 does not apply to lease agreements with a fixed end date and only applies to tenants without a lease or month to month, then the language should be amended to specifically state the same. Turning to Section 2, notably, our amendment proposes a substantial compromise here. As an industry, I want to be clear, we are generally opposed to automatic sealing of eviction records because we as business owners and landlords rely on this critical information in deciding how much risk to take on in selecting our tenant. Regardless, the market tends to take care of itself, and the markets, so as the market changes, so do we. Landlords adjust accordingly. Nevada saw this through the Great Recession, where thousands of tenants unfortunately had foreclosures or evictions on their records. And we as landlords could not and did not scrutinize an application if a prospective tenant had an eviction there, because chances are the next applicant would too. This was the sad norm. And during those years, and likely during the years that follow the pandemic, we'll see that trend, and we as landlords will be forced to look past it. We will have no choice because as the markets adjust, so do we. Regardless, existing NRS allows tenants to file a motion to seal their eviction record of any kind, and a blanket seal, as AB 141 suggests, does not protect our industry. Instead, we are offering that eviction records for non-payment of rent be automatically sealed in those cases where the tenant has signed the CDC declaration and is a covered person. Finally, we would ask this committee to consider the uncertainty that we as a nation and a state are facing. And I so appreciate the comment that rental and federal assistance dollars are lagging and insufficient. We, like many of our tenants, are hurting. As an association, we're losing $15 million a month in rental arrears in Clark County alone, and $2 million a month in Washoe. And finally, we're nearly 1 year into this moratorium, set to expire in just a few weeks on March 31st. We have no way of knowing whether it will be extended and what that means for our affordability debacle as a state. We feel now is not the time to interfere with current law, but we are willing to protect those tenants impacted by COVID. Thank you.
Thank you for your testimony, Ms. Warren. And we're going to let everyone offer testimony in opposition on the Zoom, and then we'll take some questions at that point. So I'd like to go next to Ms. Susie Vasquez, who I believe is joining us on Zoom as well. If you would like to turn your camera on and provide your testimony, please.
Thank you, Chair Yeager, Vice Chair Wynn, and members of the Assembly Judiciary. Susie Vasquez, Executive Director of the Nevada State Apartment Association, for the record. NVSAA represents 737 communities with nearly 156,000 units, 75 property management companies, and 155 supplier partners from 73 different industries. All in all, we represent 67% of all apartment units in Nevada. Mackenzie provided the reasons why we oppose AB 141 from a practical standpoint. I want to share some examples of what I've heard from my members. But first, a recent fact I stumbled upon. In 2021, Nevada has 1,100 fewer affordable low-income housing tax credit units than we did in 2020. After the 2019 legislative session, a few owners told me that was the final straw and they were pulling out. My thought was, okay, you're angry and it will pass. I was wrong. This bill may have similar implications. I am receiving on average 5 calls a week with the same story. If this passes, I'm selling. 80% of those calls are from owners with fewer than 30 units, many of which keep their rents lower than market, many times $200 to $500 per month lower in order to keep good residents. New owners will either opt to owner occupy or raise the rent to market rate. Others call regarding the eviction ceiling. We are not in the business of evicting tenants. We have heeded the call from the governor to keep people in homes. We've waited for unemployment, rent assistance, and worked with residents extensively. I'm not saying there aren't people struggling out there. As Mackenzie stated, many of us are too. But to seal evictions that do not include an attestation from a tenant regarding their COVID impact just isn't fair for those who took the required steps to be afforded that protection. Thank you.
Thank you for your testimony. Appreciate it. And we're going to go next to Ms. Tiffany Banks from the Nevada Realtors. If you'd like to go ahead and provide your testimony, please.
Good morning, Mr. Chairman and members of the committee. My name is Tiffany Banks, and I'm General Counsel for the Nevada Realtors. I'm testifying today in opposition of AB 141. We echo the sentiments laid out by the Apartment Association. I will keep my testimony concise by only focusing on Section 1 of the bill, although we have a problem with the bill in its entirety. We have worked with the Apartment Association on the proposed amendment they will present today regarding Section 2. This bill, as drafted, would mandate that landlords give tenants 60 or 90 days notice, depending on the length of tenancy. As we have heard, and as you may hear today, landlords are desperately struggling and bearing the brunt of the burden. When a landlord gives a 30-day notice, it is because the lease is in a month-to-month. Typically, after the initial lease term, the lease reads that either party can give a 30-day notice. The landlord has the right to protect their private property rights and do what they wish with their property, oftentimes to sell it because they can no longer afford to be a landlord. Sometimes a landlord doesn't know 60 or 90 days in advance that they need to move back into their property because of the loss of a job or change in their life circumstances. Existing law allows a tenant that is 60 and over or has a disability to request from their landlord an additional 30 days. We understand that some tenants may need additional time, and the law provides for that. If a landlord were to deny that request, a judge most certainly would grant it as needed. Those that truly need this additional time are afforded that. In addition, the judge has the ability to stay the execution up to 10 additional days as they see fit using their judicial discretion. This means that a tenant could potentially have 70 days notice under existing law. Unfortunately, tenants do not begin the move-out process until the very last chance they have to move out, whether through the eviction process, notice provision in the lease, or otherwise. Affording them additional notice will not solve current problems, only exacerbate them further. Thank you for your time today.
Thank you for your testimony, Ms. Banks. I'm going to go next to Mr. Dave Tina. If you could go ahead and turn your camera on and provide your testimony, please.
Good morning. I'm Dave Tiener, owner of a real estate office in Las Vegas. As your legislative chair, I am speaking today on behalf of more than 18,000 members of the Nevada Realtors who are opposed to AB 141. The Realtors advocate on behalf of both the landlord and the tenants, as both parties constitute the clientele of our Realtor members. We have concerns with Section 1 of the bill. It has nothing to do with the pandemic. We know that tenants don't move out till the last minute when the judge orders them to. An additional time for every tenant would be delaying the inevitable. The Realtors have no issues with the portion of the bill that discusses sealing of the eviction, as long as it's narrowly tailored to sealing only the non-payment of rent during the pandemic for those tenants who have signed a CDC declaration on file. Landlords understand the need for leniency. Our greatest concern stems from the unintended consequences on this bill. Mom and pop landlords have been hammered through no fault of their own from this pandemic and through the governmental moratoriums that have been put in place. They still need to make their mortgage payments, HOA payments, pay their taxes, and the governmental assistance to date has been focused on tenants initiating actions to access this assistance, rather than focusing on the mom and pop landlords and providing them assistance and relief. These small landlords are stressing that properties are becoming too difficult to manage in this environment. Anecdotally, we know and are experiencing the great influx of out-of-state buyers moving to Nevada and buying these properties as occupants from exhausted landlords, which is in turn reducing the number of available rentals for tenants. Our association is strongly committed, encouraging our members, property managers, landlords, and tenants to work together during these trying times, and we will continue to do so. Thank you.
Thank you for your testimony, Mr. Tina. And then finally on the Zoom with us, we have Mr. Daslich, who is with the Vegas Chamber. Welcome, Mr. Daslich, and please provide your testimony.
Thank you, Chairman Yeager and members of the committee, and thank you, Assemblyman Watts, for all the time that you've taken to work with the Chamber, the Realtors, the Apartment Association, and other stakeholders. The Vegas Chamber today is opposed to AB 141. We have to bring opposition to Section 1. We're opposed to providing longer-term changes to the Nevada revised statutes in the form of pandemic response bills. Section 1 is a long-term change in a bill that is responding to a situation that has been exacerbated by the pandemic. As you've heard from the Apartment Association, the Realtors, and some of the landlords, this is going to have an extreme adverse effect on not only the availability of market rate housing, but the affordability as well. This has been a challenge that the Vegas Chamber has been engaged on since before the pandemic and is very necessary as we try to diversify our economy and rebuild. The availability and affordability of market rate housing has a significant effect on the relocation of companies and industries that we desperately need as we rebuild our economy and make ourselves more resilient to future recessions and pandemics. As this pandemic and the recession that has followed has shown, we must diversify our economy, and one of the key steps in doing that is increasing our housing supply, whether that's single family, multifamily, rental properties, and owner properties. This bill would not only reduce that supply, but make it dramatically more expensive. By increasing the costs of living, we're making it more difficult for out-of-state companies to relocate to Nevada and boost our economy. We are in support of the amendments offered by the Realtors and Apartment Association, and we look forward to continuing these conversations as we search for a mutually agreeable solution. Thank you.
Thank you, Mr. Daslich, for your testimony. So committee, we've had 5 folks on the Zoom with us here. We are going to have time for questions, but to sort of keep this orderly, I think what I'll do is when we have a question, perhaps I'll go to Ms. Warren, and if you want to answer it, great. If not, if you want to designate somebody else, I just don't think we're going to have time for everybody on the Zoom to answer all the questions. So I'll go to you as point to kind of decide where that question should best be answered. So far I have 3 questions out there. We're going to go to Assemblywoman Cohen, then Assemblywoman Kasama, and then Assemblywoman Summers Armstrong. So let's start with Assemblywoman Cohen.
Thank you, Chair, and thank you all for your testimony. Ms. Warren, I want to make sure I understood what you said about Section 1. And I'm sorry, I should have written it down before everyone else testified. But are you saying that you said that if Section 1 is just for situations where you don't have a lease, that it should say that specifically? Because my understanding of tenancies at will and periodic tenancies, that type of thing, is that they don't have leases. So did I misunderstand that?
Mackenzie Warren, thank you, Assemblywoman, for the question. I believe you're talking about the portion of my testimony when I noted that, time and time again this morning, we've heard that AB 141 does not apply in the situation of a lease agreement with a fixed end date. And it only applies to tenants without a lease or those that are month to month. And so if that is the case, then we would like that explicitly stated in the bill.
Okay, so I want to make sure I'm understanding. So you're saying tenancy at will doesn't cover that, week to week doesn't cover that.
So I may have 3 letters behind my name, Mackenzie Warren, for the record. I don't practice in eviction court. I'll kick it to Tiffany Banks with the Realtors. She wants to tackle that.
Hi, Tiffany Banks for the record. Thanks, Mackenzie. So NRS 40.250 is the section of law that talks about the holdover that occurs after the period of time of the 1-year lease. And the section that this is in, section 40.251, is the section that then is covered under the month-to-month or the week-to-week. What Mackenzie is asking for is, because of how it's drafted, and again, because of the confusion that we're concerned that landlords and tenants alike will be faced with, because of how it's drafted, some landlords and tenants may think that, oh, if I've been in the property for more than a year and I've been in a fixed term lease and I've been in the property for 2 years of a fixed term, that then 251 applies or 250 applies. It leads to the confusion that we're very, very concerned with this bill, and that tiers, and just how you're confused today, our landlords and tenants are going to be confused the same way. But 250 is a specific section of law that covers the holdover that occurs after the 1-year lease, and 251 is the section that covers these month-to-month type of tenancies.
Okay, thank you for that. And so can the landlords, so the landlords can just make leases, right? I mean, that would be resolved if the landlords went ahead and made sure that they didn't have holdovers and turned those into leases.
Tiffany Banks for the record. So currently how a lot of leases read is that a lease is for a set period of time, so a 1-year lease, and then it'll say that it goes month to month thereafter until either party, either the landlord or tenant, gives a 30-day notice. So at that point, when it switches to the month to month, then yes, 40.251 applies. So a landlord and tenant would be responsible then for entering into another termed lease in that case, rather than just letting it go to month.
Right, okay, thank you.
Let's go next to Assemblywoman Kasama.
Thank you, Chair. And my question goes to Tiffany or Mackenzie, whoever wants to answer that question. Are there currently mechanisms under the current NRS statute that allows for the sealing of eviction records? Do we already have that in place?
Mackenzie Warren, for the record. Thank you, Assemblywoman. We do have that mechanism in place. And sort of the findings that a judge needs to make is if justice requires and if there are extenuating circumstances. So we view certainly fallout from COVID and the pandemic to be an extenuating circumstance. I don't have hard numbers and facts and figures, but anecdotally, for those attorneys that spend lots of time in justice court where those motions are made, judges are liberally granting the same because they want to, afford that ability to seal their record if they had an extenuating circumstance like COVID, which is why our amendment in Section 2 seeks to automatically seal those records of those that have signed that CDC declaration. And I have to push back a little bit about something that was stated in the bill presentation that tenants are finding it impossible to navigate this environment. We know that thousands of Nevadans have signed the CDC declaration, and the court codes the cases, but that CDC declaration is part of that file, and the automatic sealing would not be unduly burdensome in that regard to add the CDC declaration as a requirement for automatic sealing of non-payment evictions.
Thank you so much. Follow-up question, Chair, if I may?
Please go ahead.
So regarding the sealing of the eviction records, this proposal in Section 2, so the way you look at that, it wouldn't be only for non-payment of rent. If a person if the person was employed, had federal assistance funds, had the ability to pay, and chose not to, that person would still have their eviction records sealed under this. Currently, the way it's written, is that correct?
Mackenzie Warren, for the record, that is correct. And again, that was the intent for us to come to the table with something. And I will say that was not easy to get the apartment association and the realtors, our clients, to agree to that because the market does adjust. And, sort of an undertone of this pandemic is there's a lot of misinformation out there, but we know that there are tenants that are receiving either assistance or they've had no change in income, and that they're simply using that moratorium in an advantageous way to get out of their rental obligations. Which is why AB 141 as currently drafted protects everyone. And to us, it should be those that are truly impacted and have signed, a sworn legal document under the penalty of perjury that they've been impacted. We want to protect those people. We want to do our part as we've done, providing essential housing for the last year, in many instances, rent-free. We feel that is a fair compromise to capture those that are truly impacted and covered.
Thank you so much.
Assemblywoman Summers Armstrong.
Thank you, Chair Yeager, and thank you to all who have presented this morning. Just a couple of questions. I didn't even know that there was a CDC declaration until recently. Is part of the process since COVID happened and the moratorium for those who are members of the apartment association to provide information to their renters about the CDC declaration? Is that part of the standard process?
Mackenzie Warren, for the record, thank you, Assemblywoman. A resounding yes. We have put out email blasts, flyers, talking to tenants, going door to door in some instances. The Apartment Association has been offering the CDC declaration as a safe harbor, as it's intended to function. This is a legal document that halts the process and gives people the breathing room that they need. We've even heard in some instances that judges, right or wrong for inserting themselves in the process, are handing it to tenants that stand before them. As you've heard, legal aid is doing their part and trying to get out the word with the CDC declaration. And we know that thousands of Nevadans have taken advantage of this safe harbor and have utilized that declaration.
I would, Chair, if I could have a follow-up.
Please.
Could legal aid please speak to that? Because I think that we have conflicting information, because there has been discussion about people falling through the cracks. And I know at the beginning of the pandemic, when I had folks in my community, which by the way, before the pandemic had 15% unemployment. And I don't know where these numbers are coming from, but I know that we have 2 large casinos that are still not open. So I think that our unemployment numbers are a little higher than what was stated earlier. Could someone from legal aid please speak to whether or not the tenants that they are trying to assist knew about the CDC declaration and how that process worked?
And if I could interject for just a moment, Assemblywoman, what I'm going to ask our folks from legal aid to do, if you could hold that question and address it in your concluding remarks, just so we maintain a clear record that we're on opposition testimony. So Assemblywoman will get that question answered before the end of the meeting. But I want to make sure we're trying to keep things as orderly as possible with our committee minutes. So did you have another question for anyone who testified in opposition on the Zoom?
Yes, thank you, Chair Yeager. I'm sorry, I'm still new at this and I'm trying to figure out and manage this landscape. I guess what concerns me is how we deal with what could be devastating fallout from evictions and having an eviction record. And I know you all have your concerns, the members in your organization, and everybody is concerned, but I'm going to give you just a small anecdote, and I'd like you to help me understand how what you want could help. I have someone that I know who has an eviction on their record. And this mom, who is hardworking with 2 beautiful children, who I know and care a lot about, because of an eviction that happened that was of no fault of her own, ended up in a weekly and was paying rent in a weekly over $1,000 a month for a 1-bedroom weekly, and could not ever get ahead. Finally, something happened, broke out recently, and she was able to move. But $1,000 a month for a weekly is a lot of money. And I think that it is disingenuous, from my perspective, to ask someone who's paying that kind of money to be able in 7 days to come up with the first month rent for a new place, the security deposit for a new place. And I'm just having a hard time figuring out why the ask for 30 days or 60 days or 90 days, considering the length of a person's tenancy, in good faith, people who are paying, why this is so difficult, and why you all don't believe that stealing the records of folks during this pandemic only is such a big deal. I'm struggling with what really appears to be lack of compassion and sensitivity in this very difficult and traumatic period of time.
Mackenzie Warren for the record. Thank you, Assemblywoman. I hear 2 questions within what you just shared. And the first speaks to your example of your friend with the eviction on her record. I want to be clear, the Apartment Association does not offer weekly options. So I in no way stand here as a representative of the weeklies. We simply raise that in our testimony to illuminate an unintended consequence of this bill, in that those weekly tenants, once they stay for a month or more, they're treated as any other regular tenant. So that would be the 30-day notice as existing NRS supports. So if you were to change that, say she was able to manage that $1,000 a week and she hung around for 3 years, and now all of a sudden the landlord now needs to give this 3-month period, does that disincentivize our landlords from offering those short-term options, those weekly and those monthlies? So that's more the point I'm trying to make. And to your second question, with the declaration and where our pushback is on allowing folks to get their records sealed and the lack of compassion, I have to tell you that we've had immense compassion for our tenants. We've had some landlords that have just written rent off entirely. We've used our community clubhouses and our leasing offices as internet hubs to let kids access school. We've printed the CDC deck for them and handed it to them. We have given out toilet paper. We have given backpacks and pizzas, and that support and commitment that we provide to our tenants remains, because truly we are not in the business of evicting people. And I have to say that again, we're not in the business of evicting people. We've seen great success with payment arrangements. Of those tenants of the apartment association that are behind, nearly 70% of those people have entered into a payment arrangement with us. Our amendment simply seeks to refine the ceiling to impact those that are struggling, because we have made that CDC declaration to our tenants at every available opportunity. Legal aid is also part of that mission. Judges, other community groups, as you've heard from by testimony today, the compassion is there. We need the law to be contoured to protect both the landlord and the tenant.
Chair Yeager, one more question. Is there a financial ability for landlords and apartment owners to write off the types of losses that they may have encountered during COVID? And if that is so, and I do believe that it is, can you see the how that is and if that is so, and I do believe it is, I think that what this bill is asking is for a similar type of write-off, if you please, for those who are not property owners, who don't have tax shelters, for them to be able to make it through and get another apartment. By not allowing the write-off, quite frankly, you force people into situations of daily weeklies, because they're the only places that will take them when they have an eviction. And I understand that you all are saying that the market will correct itself, but that sounds great in theory. In actuality, that is really not what we are seeing happening. We are seeing people being unable to secure housing. So this is a really tough situation for me and my community. And I just wish that there could be some middle ground here. But regardless, I'm listening and I'm trying to understand. I really have to look out for the folks in the communities that I represent, and we are struggling. And this is really hard.
Mackenzie Warren, quickly, respectfully, Assemblywoman, we do believe that the market does correct itself, and that an eviction on your record during the years that follow COVID will not act like the scarlet letter that it does. We saw that after the Great Recession. People's credits dipped, evictions, foreclosures on the record, and you couldn't scrutinize and reject an applicant because perhaps the next person behind was going to have a similar history. So truly, as the boots on the ground, those that have been through similar emergency situations as the pandemic, the market does and it will correct itself, and landlords adjust accordingly. That is our experience. Thank you.
Thank you, Ms. Warren. I think what we are missing is that in the present right now, the detriment, people can't wait for the market to correct itself if they're looking for housing today. And if people have to get back to work, and they need some place to live, how long before the market corrects itself? And what happens in the interim? And I think that it's a small ask, because you all still have the law in your to evict people with a prior who don't pay. So I think that we've got to look at the present, the right now, and to hold up help for everyone just for a few bad actors. The sun shines on good and evil. The sun shines on nice people and bad people. And sometimes we can't parse every little thing. And how are we going to afford, do you have a suggestion on how to finance this carve out. We don't have money in the state budget. So how do you all propose to, and are you willing to pay a fee to have this carve out, to look out for these folks that you are so concerned about, who you believe don't deserve the sealing of their records?
Assemblywoman, I'm gonna encourage the two of you to perhaps continue that discussion offline. We're getting a little further away from the content of the bill, so appreciate the conversation, but want to ask you to, if you can continue that beyond the contours of the meeting, because I want to move on and make sure we have enough time to hear from some folks on the phone as well. So I want to go to two additional questions, and then we're going to go to phone testimony. So the two final questions will be from Assemblywoman Hanson and Assemblywoman Gonzalez. Please go ahead, Assemblywoman Hanson.
Thank you, Chair. And I promised it was just a quick question, but one quick comment. I hope that we all understand that this is not lack of compassion, that we have questions about legislation that can have unintended consequences that could harm the market. In particular, I have lived this. I was raised by a single. I have lived these very scenarios that have been discussed. But I've also seen landlords work with my mother. And so we're trying to navigate some difficult issues. And with that being said, my question would be to, particularly in regards to the amendment, the Nevada State Apartment Association and Nevada Realtors. So I see that there is this middle ground that we're being asked to put forth, in discussing this legislation, that in Section 2, the amendment says, an case court file that includes a signed tenant CDC declaration to allow for the sealing. I'm curious, what if you could expand on what benefits do you see for your respective membership in having it play out like this? And I'm sorry, that would be to either the apartment association or the realtors.
Mackenzie Warren, for the record. Thank you, Assemblywoman, for the question. We see it as a benefit to our members because it gives us something. And at the risk of sounding callous, I have to just share stories of what our property managers are seeing boots on the ground, is that tenants that they know have not lost their jobs. They can see the new car in the carport. They can see shopping bags. Whatever it is, they know there are tenants that are not impacted by the pandemic and are using the moratorium as a blanket excuse to avoid their rental obligations. And so our amendment protects those tenants that are truly covered, and it allows us to taper those automatic ceilings to those that are impacted, because I have to push back on another statistic from the Gwynn Center, 500,000 Nevadans facing eviction. I had one of our largest members, Ovation Property Management. They have 37 communities with nearly 9,000 units. And of those 9,000 units, just 3%, so that's 267 tenants. 267 tenants of one of the largest operators are at risk of eviction. Why, you might ask? Because we're working with the other half. There are thousands of tenants that are on a payment plan. Perhaps we're taking less now, and when things improve for them, then we can be made whole. But it's just as tenants are viewing the CDC declaration and this eviction moratorium as a way to skirt their rental obligations, that's dangerous thinking. So is throwing out a number of 500 or 500,000 Nevadans facing evictions, because our statistics belie those numbers.
Thank you, Chair. Thank you, Ms. Warren.
You're welcome. And we'll go to Assemblywoman Gonzalez for the last question for our Zoom opposition.
Hello, thank you so much, Mr. Chair. Assemblywoman Gonzalez, Assembly District 16. I kind of have two questions. My first question is in regards to the CDC declaration. I'm just curious, what is the timeline? So like if someone goes and applies for the CDC declaration, what and how long does it take for them to hear back? Is it like an automatically granted thing? And then how does that play in with stopping their eviction? And then my other question is, I've heard a lot of testimony about extending this eviction period, right? What really is the loss? If the claim is that inventory is an issue, regardless if you evict someone at a week or 90 days, you're still going to have someone that's going to fill that unit. So I'm just really trying to understand the pushback on the timeline of eviction.
Thank you, Assemblywoman Mackenzie Warren, for the record. I'll tackle the first question about the CDC declaration, and then I'll have Tiffany Banks answer the second question about the notice provisions. So to be clear, the CDC declaration is a form. It's not an application. There's no consideration or a process where it is weighed. In fact, we don't even question the veracity of this attestation, and under law, we cannot. Similarly, most judges are not questioning the veracity of this declaration because this CDC dec is a form, and it's a sworn document under penalty of perjury that when a person signs that document, they are saying that they have been impacted by COVID and are covered and cannot be evicted. So the mechanics of the CDC dec are really simple. All a tenant has to do is sign it. When they present that to their landlord, the landlord has the onus and the responsibility to get that dec on file with the court. That can happen in a matter of hours, and the eviction is stopped dead in its tracks. And one thing that I think is really important to highlight, and it's a bit in the weeds, but we're getting there. So let's go there. Las Vegas Justice Court, which by estimation handles 90% of all evictions in the state, currently has an administrative order in place. And what it's saying is that during the moratorium, if a tenant has signed the CDC declaration to obtain a stay, basically a halt to the process, there are two things. It's either removed from calendar entirely, or it's set as a status check for some time after the moratorium. So ostensibly, we'd be talking about April here, right? If the moratorium ends March 31st. So then pursuant to this administrative order, the landlord has 30 days to place that item back on calendar. And if that doesn't occur within that 30 days, then the case is sealed as if it never happened. So this is, again, yet another stopgap and another measure that is existing in this Las Vegas Justice Court order to allow those that are protected under this CDC declaration for their cases to be sealed in the event that the landlord doesn't engage. And to your point, Assemblywoman Gonzalez, won't we just find another tenant? Yes, we will. And I can't speak to whether we're going to be, filing this motion to get things back on calendar, but I'd imagine that as an industry, we're going to be highly motivated to recoup our losses and bring people in units. And we know that there's a need for that because housing is so scarce right now because the moratorium is keeping everyone hunkered in their homes, which is what needs to be done to protect those that are impacted by COVID. And then I'll hand it over to Tiffany to touch on why the notice provisions are problematic. Thanks.
Thank you, Mackenzie, and thank you, Assemblywoman Gonzalez, for your question. Tiffany Banks, for the record. So to answer your question, so the way you phrased it, and again, it goes to the confusion of this bill, this language. You mentioned, why is it bad, essentially, to give extended timelines of an eviction notice? And this is actually not an eviction notice. The timelines in this bill have to do with notice requirements in that period of the month-to-month lease. And so if a landlord is struggling, if a landlord, in the cases that we hear from our members, we have mom and pop landlords that have cancer, that need to move back into their home because they've moved out of their rental property, that they've lost their job. We hear all of these different situations from our landlords, our mom and pops, that need to gain access to their property again. And that's where the notice provision discussed in Section 1 comes in. And so giving that additional time, maybe they don't know that they need to move back in. And in this case, after all the COVID, a lot of the tenants that haven't paid rent in a year, they can't afford it. They need to sell it. They can't afford to pay the property taxes anymore. They're struggling and they're lost. And so this additional timeline for them would be astronomically bad. And so That's what this section deals with, and nothing to do with the eviction notice itself, but the timeline for just a general notice of I need to gain access again to my property for whatever reason.
Thank you so much. Just one quick follow-up, Chair, if I may. Do you have any data?
Make it very quick, please.
Do you have any data on how often this is happening, that landlords are needing to move back into their homes and that they have nowhere to go?
This is Dave Tina, Assemblywoman Hanson. Can I answer that? So basically what's going on with that, they may have two rentals and one rental is paying. So they're paying that mortgage. But then the other rental is not paying and they're losing it. So their decision is, I'm going to lose all my rentals. So let me sell this one that's available for me to tell the tenant in 30 days, let's say that they don't have a lease and they have to move. So I have to put it on the market. That money going on the market from selling the house is saving maybe their house themselves or their other rental. So on the basis, when you look at this, it's judging that they're getting paid, and it seems unreasonable that we're worrying about these days. But their situations are becoming just as dire as the tenant situation because they're losing their houses and sometimes their primary house, and they will be homeless too. So I hope that answers that situation of what's going on.
Thank you so much. I just wanted to correct the record. I'm Assemblywoman Gonzalez. I think you mentioned Assemblywoman Hanson. And it didn't answer my question. I asked if you had any data, but thank you so much. Thank you so much, Chair.
Quickly, Chair Mackenzie Warren, for the record, we'll work with the Assemblywoman to try to pull any facts and figures to answer her question. Thank you.
Great, thank you. Hopefully everyone can hear me and see me. I'm having some internet issues over here today. So here, we're gonna have to leave it at that for questions. Members, if you had additional questions that you were not able to ask, I would ask you to take those offline. And can somebody give me an indication that you can actually hear me? Okay, so I'm seeing a thumbs up. I'm sorry, my screen is a little bit frozen right now, so I wanted to make sure you could hear me. So for those in opposition on the Zoom, I want to thank you for being here. Members, if you do have additional questions, I can get you contact information for those who were on the Zoom, but I do want to go to the phone lines to take some opposition testimony. I don't know if we'll be able to get through it all. We only have about 15 minutes for it at this point, but BPS, could we go to the phone lines and see if there's anybody there in opposition? And if so, could we have the first caller give testimony, please?
Thank you, Chair. To testify in opposition of Bill AB 141, press star 9 now to take your place in the queue. With a caller with the last 3 digits of 390, please slowly state and spell your name for the record. You will have 2 minutes and may begin. Caller with the last 3 digits of 390, hit star 6 to unmute yourself and begin your testimony.
Good morning, Chairman Yeager and member of the committee. Erica Arthur, ERICA, ARTHUR, Senior Vice President of Ovation Property Management, owned by Alan Mulaski, located in Southern Nevada. We own and manage almost 9,000 units, incorporating 37 communities, including 11 communities serving low-income seniors. It is very difficult to achieve a nuisance eviction. The burden of proof can be so heavy to achieve an eviction that it becomes virtually impossible. This causes residents affected by a problematic neighbor to have to simply live with it or move out, causing the landlord additional vacancy loss, etc. I cannot think of a time we have issued a non-renewal to a quality resident who pays their rent on time. As others have stated, we are in the business of providing housing. The timeline between the no causes served and the actual time of the resident vacating can be at best uncomfortable and at worst dangerous. Some residents can become hostile and threatening, as these notices are typically used to end residency for problematic residents. Multifamily owners have been forced to carry a large financial burden throughout the pandemic. No other industry has been forced to maintain full service while essentially giving away its products for free. Food is essential, yet grocery stores still charge. Gas is important, yet gas stations still collect. Would legal aid continue to serve their clients if their funding stopped and they had to work for free? Now is not the time to place additional burden on an industry still trying to recover. On behalf of Ovation Property Management, I am in opposition to AB 141. Thank you.
Thank you for your testimony, Ms. Arthur. BPS, could we go to the next caller, please?
With the caller with the last three digits of 040, please slowly state and then spell your name for the record. You will have 2 minutes and may begin now.
Good morning, Mr. Chairman and members of the committee. My name is Vandana Bala, V-A-N-D-A-N-A, Bala, B-H-A-L-L-A, and I am a property manager at a real estate company that manages about 1,000 properties, the majority of them being mom and pop. I am testifying today in opposition of AB 141. This bill and many like it are going to keep landlords from providing a product in the marketplace that many tenants desperately need. In my experience, working with tenants, many truly cannot afford to buy a home, so renting is their only option. This legislation is going to make it harder and harder for us to provide that essential product, rental properties. Most recently, and this is not a hypothetical, it actually happened. I had a tenant that didn't pay a single dime for months. $20,000 later, the tenant appeared in court, and the judge didn't understand if the CDC or Nevada declaration applied to this tenant, even though the tenant admitted under oath that he was not eligible to apply for assistance, which is one of the declarations required for the protection. This is a tenant that has 2 children in a prestigious private school, personal golf court, brand new Mercedes in the garage, and membership to Red Rock Country Club, yet says he can't pay his rent. The judge didn't know what to do with this, but I want you to consider how someone can pay for all of this and yet not $1 in rent or utilities. We eventually got him out, and my landlord has just put this property on the market to sell. So if your goal is to have rental properties being sold, passing these types of bills will absolutely achieve that goal. Furthermore, this bill will give tenants like this yet more time to stay in a property. When thinking about the impact of this bill, imagine the shortage in rentals, which will drive the rental prices to increase at an even faster rate. Mr. Berchold mentioned that it's already hard enough for tenants to find new housing now. Think about the impact that Nevada families will face if there are less rentals than there are right now. I urge you to think about the consequences of this piece of legislation, and thank you for your time.
Thank you for your testimony, Ms. Bala. BPS, let's go to the next caller, please.
With the caller with the last three digits of 414, please slowly state and then spell your name for the record. You will have 2 minutes and may begin. Caller with the last three digits of 414, please press *6 now to unmute yourself and begin your testimony. With the caller with the last three digits of 080, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
For the record, my name is Susan Fisher, S-U-S-A-N, space F-I-S-H-E-R. Thank you, Mr. Chairman and Committee, for the opportunity to speak today. In full disclosure, I also represent the Nevada State Apartment Association and Nevada Housing Alliance, but I'm speaking today on behalf of a private business person, Mr. Leo Paggioni. I will spell his name for the record as well, L-E-O space P-O-G-G-I-O-N-E. When he was in his mid-20s, he started buying very distressed properties, predominantly manufactured modular homes, and fixing them up and using them as rental properties as an investment. He now has 35 rental properties, and they are all what you would consider affordable housing. His rents are under market rates because he wants to keep people in these homes. But with the bills that have gone through in the last sessions, and particularly in the last minute of the last session, and with the pile on with all the bills that we're considering this session and this particular bill, he's selling every single one. As people are starting to move out now, every single one is going on the market. And that takes 35 rental properties, affordable housing properties, off the market. and they're not going to be going back in as affordable for anyone because of the market in the Reno-Sparks area now has gone so high. We are in opposition to AB 141 as presented. He has indicated he could live with the bill, with the amendment that's presented by the Apartment Association and the realtors. We've heard today about inadequate investment into affordable housing. There's a reason why, because it costs just as much to maintain them, to build them, as it does market rate. So I appreciate the time to put his comments on the record. Thank you very much.
Thank you for your testimony, Ms. Fisher. Let's take the next caller, BPS.
With the caller with the last three digits of 271, that's 271, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Erica Oki, ERICA OCKEY. Good morning, Mr. Chairman and members of the committee. My name is Erica, and I'm testifying today in opposition of the proposed AB 141 bill. I would like to share my story with you and give another perspective of our devastating current situation. After years of hard work, I spent every penny of my family's savings on my first investment property in 2019. This property was purchased as a way to save for my three sons' future college tuition, down payments on homes, cars, and weddings. Our boys were involved in every step of the way, and we call them our little landlords. After celebrating our accomplishment, we accepted the application for a tenant with good income, steady employment, no pets, and good rental history. All was well until my tenant lost her job due to COVID-19. We were sympathetic, understood the situation, worked with our tenant, and allowed her to wait for her unemployment to arrive. I dropped off groceries, supplies, furniture, allowed late payment, partial payments, and still maintained repairs on the property. Rent was sporadic, but I was still coming in until about July, when the tenant stopped communicating altogether. I stopped by the property to find that my tenant could not pay her rent, but she had her nails done, eyelash extensions, Apple AirPods, an $80,000 truck in the garage, and was still doing odd jobs like Postmates on top of her unemployment. With $1,100 a week, my tenant was making more on unemployment than she was when she was employed, and stated that she had no intention of returning to work. She stopped applying for rental assistance in November and said that it was too much of an inconvenience, and I was declined for any landlord assistance. In February, I went to do another well check on the tenant to find that my tenant had moved out in the middle of the night without giving any notice. After entering the property, I found that my tenant had burned holes in the carpet, destroyed the appliances, put cigarettes and pot roaches down the sinks, trashed bathrooms, causing major plumbing issues, turned off sprinkler systems, ruining all of the landscaping, and threw a ton of unwanted personal belongings in the street, resulting in broken glass and trash everywhere. After paying multiple mortgages for the past 12 months, I was left with a $9,500 repair invoice and several months of unpaid rent. This pandemic has been tough on everybody, but landlords have been left out in the cold. Instead of worrying about keeping my family safe, I find myself working 7 days a week in order to keep our heads above water. I hope that you consider the small mom and pop investors when voting against this bill. Thank you for your time.
Thank you for your testimony, Ms. Aki. BPS, let's take the next caller, please.
With the caller with the last three digits of 169, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good morning, Chairman Yeager and committee. My name is T. Tran, that's T-T-R-A-N. I am the president of Imperium Property Management and Consulting in Northern Nevada, and my company actually spearheaded a program that did mediation to prevent evictions for the city of Sparks. I will say that I'm in opposition to both parts of this bill. There are provisions that already exist when it comes to notice to vacate, and especially for seniors and disabled persons. So I just don't feel that it's necessary to continue extending that when there are already provisions. As far as the blanket ceiling of evictions, again, Provisions already exist when tenants are served 7 days to avoid an eviction being put on their record. I think that we need to go back and enforce the measures that were passed in our last emergency session when it came to mediation and providing those resources to our tenants and our landlords to ensure that everybody's educated about what the process is and how to avoid an actual eviction being put on your record. There are so many people in our community right now who are doing that in counseling people and ensuring that actual reasonable processes are in place. So judges currently have the discretion to seal evictions. I see no reason to have this bill put in. And as others have mentioned, the long-standing effects on our market would be severe. Having worked through the recession in property management back in 2008, the market adjusts. We will make adjustments for people who do have evictions on their records due to COVID. But right now, I see that people are taking the measures that they need to actually prove hardship and all those things. So if there is going to be some sealing of evictions, I believe there needs to be an amendment that shows criteria that's been bulleted out in our eviction moratorium forms, and the judges can go by that criteria instead of just saying everybody gets a free pass, essentially. Again, T. Tran for the record, City of Sparks, and I appreciate your time. Thank you.
Thank you for your testimony, Ms. Tran. BPS, let's take the next caller, please.
With the caller with the last 3 digits of 175, please slowly state and then spell your name for the record. You will have 2 minutes and may begin now.
Lindsay Knox, LINDSAY representing the Nevada Home Builders Association. Chair Yeager and esteemed committee members, the Nevada Home Builders Association is a statewide organization governed by members of the Builders Association of Northern Nevada and the Southern Nevada Home Builders Association. The NVHBA represents home builders throughout the state and engages on issues of statewide concern to home building industry. There is no question that the COVID-19 pandemic has put an enormous stress on Nevadans and the Nevada economy. Home builders have been fortunate in their ability to provide much needed jobs to Nevadans during this pandemic. We oppose AB 141 out of a concern that it will have an unintended consequence of slowing the housing market at a time when housing supply is desperately needed to keep up with the consumer demand. A variety of legal protections are already in place to protect Nevadans struggling to pay rent due to the COVID pandemic. These include the Eviction Mediation Program, the Pandemic Unemployment Assistance Program, the CARES Housing Assistance Program, and temporary federal and state eviction moratoriums. These programs are designed to help Nevadans get through the COVID-19 pandemic. AB 141 would implement a permanent extension to eviction notice periods to Nevada, putting Nevada at the far edge of such periods throughout the country. Home builders are concerned that rules such as this will depress the construction market for multifamily rental properties, exacerbating high home prices by limiting the supply of available units. We urge the committee to reject AB 141 and allow the multifamily market to continue to grow naturally. Thank you.
Thank you for your testimony, Ms. Knox. BPS, we're going to take 2 more callers in opposition, so if we could go to our second to last caller, please.
With the caller with the last 3 digits of 871, please slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Hello, Mr. Chairman and members of the committee. Sorry, my name is Marlon Say, that's TSE, and I regrettably own a rental property in Las Vegas. After what my tenant has put me through this last year, I've now been diagnosed with anxiety disorder. I've spent sleepless nights having panic attacks, not knowing where to turn to next. I relocated because of a job 2 years ago, and I rented my home in Las Vegas as a way to offset my rent in another city. I have been furloughed for nearly a year, and I've drained my own savings to continue to pay my rent on time where I live now. My tenant has been an issue since the day she moved in. After almost a year of not paying rent and not responding at all, my property manager was finally able to get into the unit because there were numerous lease violations occurring. To our astonishment and horror, an entirely different family was living there that said that they were related to the tenant. The locks had been changed and some of my furniture was missing. These new tenants had a pet that had destroyed the carpet when the original lease did not allow for a pet. I am still responsible for for property management fees, property taxes, LID, HOA fees, and with no money coming in since the eviction moratorium began at the end of March 2020. I don't know what my options are. I don't even have the option of moving back to my home or selling. My hands are kind of tied. I am the sole provider for my family, and I'm not urging you, but begging you to require that tenants take accountability for their own actions. There has to be a fair and judicial process. Thank you.
Thank you for your testimony, Mr. Say. BPS, let's take one last caller, please.
With a caller with the last three digits of 414, slowly state and then spell your name for the record. You will have 2 minutes and may begin now.
Chairman Yeager and members of the committee, my name is Tom Blanchard, TOMBLANCHARD, and I'm a real estate broker in Las Vegas. I'm testifying today in opposition to AB 141. Prior to becoming a realtor, I was a medic in the United States Navy, and our office manages approximately 1,000 rental properties in the Las Vegas Valley. And I value the importance of having laws that protect both the tenant and the landlord. A large amount of the homes in Las Vegas are rental properties, which means that a good number of the population relies on landlords to continue in the business of renting their properties. If this bill passes, clients have instructed us to sell their properties, which means that most of these properties will be bought up by homeowners that intend to reside in their homes, which would create even less rental properties available to tenants. Mom and pop landlords are just finding it increasingly difficult to survive in this market. Most concerning is the extended timeline for notice in Section 1. We have always given tenants that truly need additional time, more time. Landlords will never recoup money they spend fixing their property after a tenant has had time to damage it, and giving additional time will lead to a substantial increase in damage to properties. As a real estate professional with boots on the ground, we know the impact real estate has on our Nevada economy. Our Association of Realtors is always willing to work with this committee to find some practical solution for Nevada homeowners and renters. Thank you for your time.
Thank you for your testimony, Mr. Blanchard, and thank you for your service as well. We're going to leave opposition testimony there. I believe there were other folks on the line, but in the interest of time, we simply have to move on. So if you were on the line and wanted to give opposition testimony, I'm sorry we were not able to accommodate your testimony at the meeting, but I would encourage you to provide any comments that you have in writing to the committee, and we'll be sure to review those. So I'll close opposition testimony. I'm now going to open it up for neutral testimony on Assembly Bill 141. I don't believe we have anyone in neutral on the Zoom with us, but BPS, could we go to the phone to see if there's anybody who'd like to give neutral testimony on Assembly Bill 141?
To testify in the neutral position on Bill AB 141, press star 9 now to take your place in the queue. With the caller with the last three digits of 584, please slowly state and then spell your name for the record. You will have 2 minutes and we begin now. Caller with the last three digits of 584, please press star 6 to unmute yourself and begin your testimony.
Good morning, members of the committee and Chairman Yeager. My name is Jennifer Richards, JENNIFER I was appointed by the governor to serve as the Chief Elder and Disability Rights Attorney for the state of Nevada, which is housed within the Aging and Disability Services Division. I also serve as the state legal assistance developer under the Older Americans Act and oversee our legal assistance providers throughout the state. Since many individuals in the aging and disability community are at a higher risk for contracting the coronavirus, including the over 400,000 older adults social distancing in Nevada, it is critical to maintain access to stable housing, nutrition services, and personal care services. For seniors and persons with disabilities, housing insecurity can have a devastating effect from which they may never recover. They may face loss of access to necessary medication, access to health care, and access to important documentation. They are also at a higher risk of being hospitalized and subsequently institutionalized. I have submitted written testimony, including an issue brief from Justice and Aging on rental burdens for older adults, and Nevada's 2021 Elders Count, which provides authoritative data on the status of older adults in Nevada. Across all racial and ethnic categories, a higher proportion of older renter households face significant rental cost burdens compared to the rental population as a whole. I won't repeat my written testimony, but some facts to highlight from the Nevada Elders Count is that our multi-generational households are trending upwards in this state. Nevada grandparents living with their own grandchildren is much higher in Southern Nevada than the national average. In addition, Social Security benefits are the primary source of income for many older adults in Nevada, which leads many to stay in the labor force as they age. Additionally, housing and transportation are the largest categories of expenditures for our older adults over 65. And homelessness, especially in Northern Nevada, is increasing as housing costs increase in our state. Finally, Nevada's rate for those 65 and over living in poverty is above the national average and likely to increase as our state's older population is increasing at much higher rates than the rest of the nation. I encourage you to look at these resources to inform your decisions on this issue. From our division, it is important that we connect individuals to services so that we can ease the burden on crisis resources throughout the state and help people age in place. Thank you very much.
Thank you for your testimony, Ms. Richards. BPS, is there anybody else who'd like to give neutral testimony?
Chair, there are no more people who want to give neutral testimony.
Thank you so much, BPS. I will close neutral testimony. And before we do closings on the bill, I just would like to note for the record, I've been keeping a track of time and trying to keep this hearing as fair as possible. So we spent about an hour and 15 minutes on the presentation and questions. We had 35 minutes of supportive testimony, and then we took an hour and 8 minutes of opposition testimony and questions. So we did give opposition a little bit more time than support to be able to get through that. And then, of course, we just had neutral testimony, which was just a few minutes. But I wanted to, again, apologize to those who were not able to participate today. We do the best we can in the time frame we have to hear these bills, but would again encourage anybody to provide additional comments in writing if they have them. So if I haven't already done that, I'll close neutral testimony. I'll turn it back over to Assemblyman Watts and our friends from Legal Aid. And if I could just remind someone from Legal Aid to address Ms. Assemblywoman Summers Armstrong question in your closing, that would be helpful. So Assemblyman Watts, I'll turn it over to you.
Thank you, Mr. Chair, and I'll turn it over to Legal Aid to answer that question first before making my closing remarks.
Thank you. Bailey Bordelin, for the record, representing the Nevada Coalition of Legal Service Providers. Thank you for the robust conversation and the time that you have given to this issue. It has been the issue of the year for us. It's been a really long year trying to keep people housed, and I know everyone's temperatures are very high. I apologize. I'm not trying to be cheesy. It's just been a really long year. And so I appreciate Assemblyman Watts bringing this bill and really spending some time on what is realistic, what doesn't take the bar too far, what doesn't turn the system upside down, but what gets people a little bit of what they need right now. So to Assemblywoman's question that was posed earlier to Legal Aid, has it been, do most people get legal aid, was sort of the question I interpreted, and you can remind me if that wasn't quite your question. But the Nevada State Bar, in conjunction with the Access to Justice Commission run by the Nevada Supreme Court, We did fairly recently do a study, a legal needs study on the state of Nevada, and were people's legal needs being met? And this was pre-pandemic. And what we found pre-pandemic is that 76% of people who can't afford to hire a private attorney have their legal needs go unmet. So what that has meant for us this year is sort of akin to what we've seen with Dieter, right? So Dieter was there and they were doing everything that they could, and they just weren't prepared. And we have turned our lives inside out to help as many people as we can. We have hired additional staffs. We've also taken funding cuts. We've also taken the hit. But we cannot keep up with the sheer volume of legal needs, especially in evictions and housing that people are facing. So for the lucky few that do get through to a legal aid provider that are able to connect with us, you have someone to help you navigate the process. And we've taken people out of every department. We've taken people off of every issue that we have, and we have funneled it into trying to prevent evictions in every way, shape, and form. We have been working with the courts and the Supreme Court. We've been working on the mediation program, the rental assistance. It's so many moving pieces, and I cannot stress how many people statewide have put so much effort into this year. So no, not everyone knows that this is happening. And I think the prime example of what we see on a day-to-day basis is that we run the Civil Law Self-Help Center inside of the Las Vegas Justice Court, and we call that our legal emergency room, because that's where people come when they have a legal emergency, typically related to housing and evictions, and they don't know what to do or how to file or what comes next or what the rules are or where to find help. And we triage and we get people connected with attorneys and forms and assistants. And I will say to this day, the vast majority of people that walk into that office when it's open or who are calling our lines, we've set up texting and emailing and phone calls to try to continue to serve people during the pandemic. The vast majority still at this point in March have no idea that there is a CDC protection. They have no idea that there is a CDC declaration. They just know that they're being evicted and that they're in a crisis and they need help. And we triage from there. And those are the people that know how to reach us, that know that there's a civil law self-help center. So it's something that we grapple with every day, that we cannot meet the legal needs. And we are helping as many people as we can, but the vast majority of people just simply do not know how to take advantage of the eviction protections that have been put in place. So that is why we were very excited when Assemblyman Watts proposed these ideas. And why we thought that he was meeting the mark on how to make that record sealing piece targeted and narrow in scope. Because I'll be honest, after the year we've had, my personal opinion is that we should seal absolutely everybody's evictions. We should just call it a wash. It's been a terrible year and we shouldn't have that follow people forward. But by just doing the non-payment of rents, it is targeted, and then we'll go from there. People who are evicted for no cause because the non-payments were paused, but were really evicted because they couldn't pay, we'll try to find them and we'll try to educate them and we'll try to help them go through that record sealing process in that way. So I appreciate the emotions and the temperatures and what everyone has said here today. To channel John Pirro, your resident quoter of this committee, something that I deal with, my mantra has been, we're all weathering the same storm, but we're in different boats. And the people that we are serving show up to the courthouse with their suitcases because they just don't know where they're going next. And this isn't the solution, but this is a small piece of something that we can do to make things a little bit easier for people. And I appreciate you guys spending so much time and really working through this and digging into what it means and what we can do for people.
Thank you, Ms. Bordelon. Appreciate it. Assemblyman Watts?
Thank you, Mr. Chair. I'll be as brief as I possibly can. I just also want to acknowledge this hearing has again resurfaced the unbelievable human toll that this pandemic has taken on this state, on our community, on everyone. The health toll, the emotional toll, the mental toll, the financial toll. And I want to recognize that applies no matter whether you're a property owner or a tenant. It applies. This pandemic has touched us all. And I really appreciate the questions from the members of this committee. I appreciate the opposition for engaging in the discussion and trying to find some way that we can advance some protections for folks that are in need. Really briefly, I'll speak to each section of the bill. To section one thing that we didn't really get clearly covered for the record, but it is in the amendment, is that we also want to clarify that this does not apply to commercial properties. We had been reached out to by NAIOP about that, and they wanted to, I think they'll be sending a letter, but wanted to express that they are neutral on the legislation with the proposed amendment. The other thing I'll just say about notice is, I did a count, and there is some form of extended notice past what we currently offer here in the state. In many, know that some are considered hostile to landlords like California and New York, but in Colorado, Delaware, Florida, Georgia, Hawaii, Illinois, Missouri, North Carolina, Oregon, Vermont are other states that have some notice provision that is beyond what we currently offer here in the state of Nevada. Other states, again, are moving past having an eviction without cause at all. And, I think that it is certainly possible for us to make this adjustment for stable tenants who are not, to make sure that they have the ability to figure out what comes next for them, and that we can do that without it causing chaos in our housing market. And these are changes that do exist elsewhere, and they're getting by. I think on section 2 with the ceiling, we recognize that there are no perfect solutions. These are difficult issues. It would be great if we could have a court look at every single case one by one and really figure out what is the just and right outcome. We're hoping that we get more federal resources to support people, but what we know is that when these protections expire, there's going to be a backlog of thousands, tens of thousands, potentially, of evictions that are going to have to go through the courts. And I think that it puts an additional burden to also have to process thousands or tens of thousands of individual record sealing decisions to see who qualifies and who doesn't. Even under the proposed amendment by the opposition, somebody who is malicious could sign a CDC declaration and be protected. So it's difficult there is not a policy that really accounts for every individual circumstance. And so what Assembly Bill 141 seeks to do is to create a systemic solution that helps make sure that people aren't falling through the cracks. I know that there's concerns about wanting this information on the one hand from the opposition, but also stating that the information doesn't really matter because the market will adjust. So I would prefer that we have the policy certainty in Assembly Bill 141 to ensure that this does not follow people and create those collateral consequences when they look to find their next housing. So with that, again, I thank you all for your time, for your attention, and for your consideration, and I urge your support for Assembly Bill 141.
Thank you. I want to thank Ms. Bordelin and Mr. Birchtold for the work that you do day in, day out, helping our most vulnerable. It certainly has been a trying year for all of us, but definitely not any more so than those who were already struggling going into the pandemic. And thank you for being here this morning to present. Thank you, Assemblyman Watts. It was good to have you back in the Assembly Judiciary Committee. Hopefully we'll have a chance to see you back here again soon. And I want to thank all three of you for presenting, and hope you have a great rest of the day. So I'm going to close the hearing now on Assembly Bill 141. That takes us to our next item on the agenda, which is public comment. By way of reminder, we reserve up to 30 minutes for public comment at the end of each meeting. Public commenters will have up to 2 minutes to provide public comment. And just to note, public comment really is a time for individuals to address matters of a general nature that are within the jurisdiction of the Assembly Judiciary Committee. Public comment is not a time to rehash arguments on a bill, or not a time to provide comments that you're not able to provide during the bill hearings. As we've now closed Assembly Bill 141, I would just note to anyone still on the line that this is not the time to testify on that bill. That time has now passed. This is a time for public comment of a general nature. BPS, could we go to the public comment line and see if there's anybody there who'd like to give public comment?
To provide public comment, press *9 now to take your place in the queue. Would the caller with the last 3 digits of 556 please slowly state and spell your name for the record? You will have 2 minutes and may begin.
Anne Marie Grant, Annemare. My brother Thomas Purdy was hogtied by Reno police on 10/4/2015 during a mental health crisis. Instead of getting him medical attention, they hogtied him and dumped him up at Washoe County Jail. Instead of the deputies heeding the pleas of my brother for his life, they chose to smother him to death. He was the second of 3 homicides at the hands of deputies at the jail within 1 year. There have already been 4 deaths under the new Sheriff Balaam, who took office in 2019. While the media has been told it was suicide, I feel it's a little preliminary for them to be making that determination. This death should concern all of you. The county commissioners are required to get a biannual report from the sheriff per NRS 211.030. The last time he gave his report was 4/23/2019. I also wanted to mention that the jail medical vendor, NavCare, was contributed to $5,000 campaign contributions to Sheriff Balaam shortly before Election Day. NavCare is a jail medical vendor that was present when my brother and all 3 men were killed at the jail. Their contract went on to get renewed after Balaam was reelected. Please do not support bills that protect bad police. Please support bills that promote transparency and accountability. Thank you.
Thank you for your public comment, Ms. Grant. BPS, is there anybody else who'd like to give public comment?
Chair, the public line is open and working. There are no more callers wishing to give public comment at this time.
Thank you so much, BPS. And as always, thank you for helping us manage the phone line. There were a lot of people on there today, so we appreciate the work that you're doing to make these meetings possible. With that, I'll close public comment. Anything from committee members this morning before we make announcements? I don't see anything. I want to thank all of you. Obviously, it was a very long morning and a very in-depth hearing, but I think the record that was made on that bill is one that we can be proud of. We asked good questions. We treated each other with respect, even though we may not agree on the policy. And I think that really highlights the best of the legislative process, and certainly can make all of your constituents proud. So thank you for that hearing this morning. In terms of where we go from here, tomorrow morning, we do have a committee meeting at 8 o'clock. We have 2 bills on the agenda tomorrow. I don't believe our agendas are out yet, but as of now, we are planning to have committee meetings at least Monday through Wednesday of next week. Monday is going to be a 9 a.m. start, so we should get an extra hour in the morning. But that's sort of where we're going from there, and we'll get those agendas out soon so you have an idea of what bills might be heard. So with all that behind us, I want to wish you all a really great rest of the day, and I'll see you back here in this committee tomorrow morning at 8 o'clock. This meeting is adjourned.
Bye. Thank you, Chair.
Bye.